unexpected. Dissent is not foreign to a democracy. It is essential to its survival.
Sana sa palengke na lang final ang impeachment case. At least doon, may nagtitinda ng totoo. Sana po, imperil the integrity of our democratic institutions, especially when appropriate legal remedies remain available within the framework of our constitutional system. President, do it in the right way. Hindi naman po tinignan ng merito eh. Ang sinasabi yung proseso, hindi po nyo sinunod eh. Sinasabi na nga, walang impeachment complaint bukod sa isa. Laban sa isang opisyal sa loob ng isang akalain mo namang apat po kagad ang ipinay. Pagkatapos yung apat, i-consider mo na isa. Hindi naman po yata tama yun, Mr. President.
O, diba? Baliktad si MATCOLETA.
Mr. President, gusto ko pong basahin isang parte ng official statement of the Integrated Bar of the Philippines and the Supreme Court's decision in DUTERTE versus House of Representatives, August 1, 2025.
Baliktara na.
And I quote, "Disagreement with the court's reasoning is neither unwelcome nor unexpected. Dissent is not foreign to a democracy. It is essential to its survival. But to incite public repudiation of its authority, or even just to call for its outright defiance, erodes the very foundation of the legal order. Such actions disturb the equilibrium of powers and imperil the integrity of our democratic institutions, especially when appropriate legal remedies remain available within the framework of our constitutional system. If every adverse ruling becomes an invitation to disobey, the law ceases to be a constraint on power and becomes its casualty. The Constitution does not require agreement. It demands adherence." Ang sinasabi po ng mga ibang kasama natin, magpapile pa naman ng motion for reconsideration. Bakit hindi natin hintayin? As I said, Mr. President, if you are a practicing lawyer worth your salt, you are confronted with the unanimous decision of the Supreme Court. In a firm voice, it says this is unconstitutional, void ab initio, violative of due process, and the Senate never acquired jurisdiction over this. And it is immediately executed. Parang sinasabi niya sa'yo, wala ka ng room mag-file niyan. Is anyone expecting that even one soul of the members of the Supreme Court will reverse himself? We cannot depend our action, Mr. President, on the fortunes of litigation. Naalala ko pa nga po doon sa kaso ng Francisco versus House of Representatives, the former Chief Justice Renato Puno, in his separate concurring opinion, naalala ko po ang sabi niya, with the possibility of 2 impeachment complaints reaching the Senate, the good Chief Justice said that the Senate, in the exercise of its primary jurisdiction, can decide the question of whether or not the 1-year bar rule has been violated or not. The Senate can even decide if on its face the impeachment complaint has no legal basis. At ang sabi pa po niya doon, Francisco versus House of Representatives, sabi pa niya ron if the Senate finds that the 1-year bar rule is violated, or that the impeachment complaint has no legs to stand on, that will be the end of the entire controversy. He was saying that let's give all the remedies available to the House and the Senate because of their primary jurisdiction and the dominance of the fundamental law of the land, the Constitution. And so
yun guys, no, nakita natin si MATCOLETA. Talagang ano pa rin, ayaw niya rin, and tiningnan niya na talaga daw may nilabag ang House of Representative at 4 na raw po ang na-file na impeachment, no? Kaya hindi raw talaga pwedeng ipagpatuloy ang impeachment. Kaya si Marcoleta ay kunya-kunyari lang nagsasabi na ituloy ang impeachment. Ituloy ang impeachment pagdating ng oras ay hindi naman pala. So, ibig sabihin, ang House of Representative ay hindi alam ang batas na ito, ang constitution na ito, no? Hindi nila alam na hindi pwede pala yung 4 at bagkus ay nagtatanga-tangahan sila. Yun ang ibig sabihin ni Marcoleta. No, so Marcoleta talaga ang pagmumukha nito. Nanggigigil ako kay Marcoleta, rising flag, no?
The Supreme Court has already spoken. The last arbiter of law. It says the complaint is unconstitutional. It's void ab initio. It's violative of due process. The Senate never acquired jurisdiction over this. It is immediately executory. On that note, Mr. President,
So,
I respectfully move that the impeachment complaint be dismissed. I so move, Mr. President.
Relax.
Majority Floor Leader. Mr. President, before, Mr. President, we act on the motion of the distinguished gentleman from the great province of Tarlac and Rizal. Mr. President, the motion is not among the privileged motions listed under our
gentleman from Tarlac favor me with the appeal by virtue of the MR or the motion for reconsideration filed last Monday by the House of Representatives. Is it not, Your Honor?
The question whether is it
Yes, your basis for your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor. That's very, very clear and categorical.
Diba?
Correct.
So,
The Supreme Court decision,
si
Mr.
Marcoleta ay dismiss ang kanyang boto. Alam na natin yan, wala na. Kasi nga, sinabi nga raw ng Supreme Court na unconstitutional ang impeachment na to. So, yun.
President, although immediately executory, is not yet final.
Diba?
Thus, appealable. Ngayon, naka-appeal na. Marami nagtatanong kung naka-appeal na, ba't tayo nagmamadali? I-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes.
Nabaw ni
May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess, because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping against hope. It is as if we are wishing for the moon. Palagay nyo po, palagay nyo lang po mayroong isa na nag-reverse. Hindi rin po ma-overturn eh. Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babaligta rin po nila yung kanyang sarili. Kaya napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President. And to remind everyone, the reversal of the Supreme Court's own decision is not impossible, even in landmark cases. of Labogal, Bilaan Tribal Association Incorporated versus Victor Ramos, GR number 127882, December 1st, 2004, questioning the constitutionality of Republic Act 7942 or the mining law, the Philippine mining law. The Supreme Court granted the MR, reversing and setting aside its earlier ruling. And also, Mr. President, just a few days ago, just a few days ago, the Supreme Court reversed its own ruling on the definition of a stockholder. This is the case of Lily Lopez versus Lolito Lopez with GR numbers 25497-957-58. So may kasabihan po tayo, ang tumatakbo ng matulin, kung matinik ay malalim. Kaya dapat siguro pag-isipan muna natin kung tama ba na bago magdesisyon ang Supreme Court, basta ibasura na natin ang kaso na ito.
Unang-una po, Mr. President, gusto kong malaman, yung po bang mga kasong sinabi nyo, unanimous decisions po ba lahat?
I am not sure about that. But one thing I can say is that if there is a mistake, unanimous decision could become a unanimous mistake.
Wala pa pong nangyari gano'n, Mr. President. At saka po tayo, pag nananakbo, ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Well, Mr. President, there's always a first time. Regardless of whether it's unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure. Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate or in the impeachment court? Didn't the impeachment court throw it back, remanded, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ang kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands? Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings noong 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyang ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives. Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-taasang hukuman na gumawa ng paraan para...
Guys, pinagtsatsyata na lang tayo ng mga senador, Sabi siguro nyo, nawala na yan. Talagang ano na yan. Dismiss na yan, Nagchat-chat na lang, Wala na.
Isang tabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Thank you, Mr. President. Your Honor, thank you. But as I said earlier, that because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question. But then, I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Tarlac has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the one-year ban has set in? With that question, allow me to proceed with my manifestation with your permission, Mr. President. For the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, the House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress. To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, excuse me, erroneously believed that the said adjournment is the same adjournment with the sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies.
Tama.
The treaties, bills, resolutions, anything filed continues. It does not, it is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. Eh, may mali agad eh. Pati ba legislative rules natin gusto nila palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress, but us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case, nag-adjourn daw yung 19th Congress.
Adjourn pa more.
Kaya na-archive lahat.
Adjourn pa more.
Now,
Mawawala
may kinopya lang, kopya, pangalipa. Sabi nga kanina ng ating distinguished gentleman from Tarlac.
Tama.
Hilaw.
Doon ka lang sa Itbulaga.
Hilaw yung complaint. Hilaw din yung decision.
Supreme Court.
In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives
Alam ka?
that the three impeachment
Binabaluktot na nga nila eh. Ang batas sa Senado Binabaluktot na nila, ha? Biruin mo 19 Congress, hindi raw pwede magpatuloy sa 20th Congress. Anong klase yon? Bakit ilan ba silang kongreso? Ilan lang ba yung papalitan sa kanila? Ha? Meron namang matitira sa kanila, kahit naman yung senator merong natitira. O bakit hindi pwede magpatuloy yan? Yan yung sinasabi ni Soto ngayon. Nangongopya na nga, mali pa.
complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the fourth complaint were already filed and transmitted to the Senate. Dito pa lang, Mr. President, pilit na patunayan na barred ang fourth complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related.
Research niya po
The
yan.
Supreme Court,
Research niya yan.
by the way, if it is wrong, if the complaint
Dito Soto.
that done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the third mode of filing of impeachment complaint. This third
Edwin.
and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the third mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? Constitutionalists or CONCON delegates Munsud, Ascuda, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively.
Tama yung
However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga nitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun I've read
Senado talaga yung mag-aano
that the basis for the retroactive application of the new definitions because the Senate now has not acquired jurisdiction yet. Eh, Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court? Nag-robe pa kayo. You even sent out summons. Mali yun. June 9, the Senate President took his oath. June 10, nag-convene an impeachment court. Niremand to the House of Representatives. Tapos yung issue of the summons to the defense.
Ama yan, Rolando.
Eh, ano po tawag doon?
Oh, di ba?
Hindi nag-convene?
May
Baka hindi napalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So, now, just an observation. I will try to
Namumula si
shorten this, Mr. President. Just an observation, Mr. President. Well, not only myself, but several lawyers mentioned this to me, including my godson, former Senate President Aquilino Pimentel III. Naguluhan sila sa pagkakasulat ng desisyon. It is incoherent and some parts are off topic, sabi nila. Para bang pinagtagpi-tagpi. Basahin niyo mabuti. Uli, ang daming gagaling ng mga abogado rito. Basahin niyo. It even quoted the entire Article 11 of the Constitution not only once, but twice. It seems there were two ponentes. Parang dalawa author dito. Well, that is there in my observations. Just an observation. So, Mr. President, the personalities in this present impeachment case is of no moment to me. The Vice President is a friend of mine. The former President, President Duterte, has been my friend since 1988. Everybody knows that. What I'm pointing out is the danger of outright dismissing the impeachment proceedings by virtue of a decision that is not yet final and still pending appeal. Justice Leoded himself said, Mr. President, I quote, "The Supreme Court is not perfect. Citizens and academics certainly
Oo,
have the right to
nagkamali
call
nga raw ang
attention
Supreme
to
Court.
the
Paano? Bida-bida
fallibility
din eh.
of the courts." Tama po yun. There is no perfect institution. Even Supreme Court ka, pwede mag-commit ng grave abuse of discretion or culpable violation of the Constitution. A case decided unanimously does not mean that it is infallible. For all we know, it is a unanimous mistake. That again can be corrected.
Bisdak,
by
paano
setting
naging
aside
senator yan
and
kung hindi yan
reversing
marunong
prior
ng batas?
pronouncements. Again, they have filed, the HRP has the Office of the Solicitor
Talagang
General has
BBM
filed the
ako.
MR.
Impeach Sara
Monday.
ako. Dapat
So,
i-impeach,
in
ha?
this regard,
At kayo,
We shall wait
dibiles
for the
ba kayo,
resolution
ano?
of the MR. Please
Motivation.
let us allow and give chance to the Supreme Court to rectify its decision, which contains clear and blatant errors. For their sake and for the sake of future proceedings, let us not dismiss forthwith.
Oh, forthwith nga
And in
eh.
that light, considering the motion of the gentleman to motion to dismiss, I move to table the motion to dismiss. A motion to table is a higher precedence than a motion to dismiss. Thank you, Mr. President.
Mr. President, may I have a quick reaction to the manifestation of the gentleman?
The gentleman may do so if he so desires.
Mr. President, in the answer of the Solicitor General in behalf of the House of Representatives, there was already a categorical admission that the three initial complaints prior to the fourth one were dismissed because they were all archived. As I have said, archiving is not part of the rules of impeachment of the House of Representatives, but they just did it. Palusot lamang po yun, Mr. President. Paano mo i-archive nang hindi mo susundin yung tatlong steps na sinasabi ng sarili nilang tuntunin? These are not baby steps. These are constitutional steps. At kanina po ipinakita yung slides na yung inclusion in the 10th session day is constitutional. The referral to an appropriate committee is constitutional.
Wala, ayaw nyo lang.
There was no referral to any committee. Ang ginawa po nila, tinransmit nila sa Senate without requiring themselves to observe another provision of their own rules. This is to refer to the Justice Committee, where the Vice President might probably be given at least a modicum of right to defend themselves. That is what we call due process. Wala po eh. Inakala po nila na kapag may 1/3 na or more, ay pwede na nilang
So, ayaw
huwag gamitin yung Section 2 ng kanilang rules. Hindi po nakalagay yun eh.
Hayaan mo na.
So hindi na po, hindi na po kailangan na i-distinguish pa natin yung adjournment and sine die adjournment. Kasi inadmit na rin po na in-archive nila kahit na wala po sa tuntunin. Kanina sa manifestation, tinanong din po. Kung wala tayong jurisdiction, paano yung unang initial proceedings? Pwede po yung initial proceedings ninyo will be considered under the doctrine of operative facts. Hindi pa po na-declare na wala pang jurisdiction ang Senate at that time. Ngayon lang po nangyari. Kaya po yung ginawa ng Senate of the 19th Congress, tama pa rin po eh. Wala pa pong declaration noon. Kaya lang, kagaya po ng aking clarification na sinabi, all these initial proceedings conducted in the Senate of the 19th Congress were not officially transmitted to the 20th Congress where I myself belong, a Congress of different composition. So yun po ngayon, naharap tayo ngayon sa issue na talagang tayo lamang po ang gagawa because there is no other agency of government that will execute that decision of the Supreme Court. Only the Senate. So may I go back to the first question, to the original motion, Mr. President.
Mr. President, if I may.
Majority Floor Leader.
Thank you, Mr. President. With the indulgence of my colleagues, Mr. President, our Senate Minority Leader, Senator Soto, and first movement of the motion, Mr. President, Senator Marcoleta, may I respectfully appeal, Mr. President, of our, and remind, Mr. President, our colleagues of our concurrence during our caucus held last week that we will debate on this and talk about this and discuss this matter, Mr. President. But if the minority leader would continue to insist his motion, Mr. President, we have no other choice but to dispose with the motion of the minority leader, considering that it takes precedence, Mr. President, with the motion of Senator Marcoleta.
It is the understanding of the Chair that during our all-member caucus, which the Chair announced in plenary, that it was agreed unanimously by all the members that we will be discussing, debating, and acting on the Supreme Court decision on a date certain. And this
I-abolish talaga yan pagka yung hindi talaga na-impeach si Sara. Tandaan nyo yan. I-abolish tong
was the date certain that was agreed upon in caucus. Maybe here from the distinguished minority floor leader, if there has been a change in that position given on that date when we had an all-member caucus.
Mr. President, I as a matter of fact, concur with what you said. But during that time when we discussed it, there was no MR file. There was no motion for reconsideration filed by the House of Representatives or the Solicitor General. So it becomes a different, it develops into a different scenario now that there is a motion for reconsideration. Because again, my question was not clearly answered when I said, what happens if we move to dismiss as as Senate or as impeachment court, I think that is one of the questions that is going to be posed by another member of the Senate, and we wish that you could recognize them to continue debate on this matter before we decide. But again, my answer is that there was no motion for reconsideration when we agreed to decide on August 6 on the motion to dismiss. That's why my motion is not against the motion to dismiss, Mr. President. It is merely a motion to table the motion to dismiss, which you may be able to take up on the floor even tonight or tomorrow. A motion to table is alive always in parliamentary rules, and you may take it up anytime. Then we can take up the motion to dismiss after that, Mr. President. Thank you.
We note the intent of the distinguished minority floor leader, but the chair would therefore like to make some points known before we act on the motion. What is the pleasure of the majority floor leader?
Mr. President, upon conferment with the minority leader, Mr. President, he is amenable, Mr. President, for us to continue with the discussions and debate on this particular topic, Mr. President. And so with that, Mr. President, may I move that we
Pero talagang pagboboto.
recognize the distinguished gentleman from Cavite, Senator Panfilo Ping Lacson, to ask his questions, Mr. President.
Well, first, the chair would like to thank the
Thank you,
magnanimity
Mr. President.
of the distinguished minority floor leader in order for us to be able to continue with the debates. The gentleman from MATCOLETA so desires.
Thank you, Mr. President. This is not an interpellation. Rather, this is a manifestation to be followed by a parliamentary inquiry.
The gentleman may proceed.
Mr. President, I've been diligently reading and reviewing the rules of the Senate since I've been out of this August chamber for 3 years. Nowhere in our rules can I find a provision on a motion to dismiss as submitted by the honorable gentleman from Tarlac. Neither is there a supplementary application of the rules of court to offer space for such motion to dismiss, except perhaps in the committees performing their legislative inquiries in aid of legislation. Obviously, we are now assembled in plenary, not as an impeachment court, but as a legislative body, and I cannot relate to a motion in this plenary to an issue that involves a collective decision that falls solely and exclusively under the jurisdiction and authority of an impeachment court. Having said that, Mr. President, my parliamentary inquiry is addressed, of course, to the Senate President. Mr. President, how do we deal with the pending motion? I refer to the motion to dismiss. Shall we even take it up or deal with it? Kasi wala po sa rules natin. Paano wala tayo pong guidelines? Kasi wala po sa rules natin yung motion to dismiss. So anong guidelines ang susundin natin in addressing the motion to dismiss submitted by the Honorable MATCOLETA? Assuming arguendo, Mr. President, that the motion is voted upon and adopted by this body, what if, Mr. President, the Supreme Court reverses itself when it rules on the MR filed by the House of Representatives through the Solgen? Shall we also backtrack and reverse ourselves in dismissing the impeachment case? I pose that question, Mr. President. Thank you.
Thank you, Senator Lacson. To respond, we were faced with this question, but the very people asking us to wait right now were the very same people who were telling us before to ignore the pendency of a case in the Supreme Court precisely regarding this impeachment complaint. They were egging the Senate, even if we were on recess, to precisely proceed with the trial in spite and despite the pendency of cases in the Supreme Court. And the chair, with an abundance of caution, same with this good senator right now, decided to afford the Supreme Court time during the recess to decide on the matter. And when they did not, the Senate, in accordance with its duty, convened the impeachment court when we resumed session, given that we cannot conduct impeachment proceedings that have not yet begun yet during the recess. To answer the query with respect to motion to dismiss, this was actually done, although not via a motion to dismiss, but a motion to archive in relation to the impeachment complaints of then President Estrada and Ombudsman Gutierrez. In fact, in the case of Ombudsman Gutierrez, it was our distinguished minority floor leader himself, acting as majority leader, I believe, who moved that the case be archived, given the resignation of then Ombudsman Gutierrez for being moot. In the case of President Estrada, the case was likewise archived for being functus officio, given that EDSA DOS happened and a new president was sworn into office. Your Honor, I believe the chair believes that we will have different interpretations of the effect of the Supreme Court decision. But ultimately, as I discussed with the majority leader earlier, once a decision is made by the Senate and the period to seek a reconsideration of that decision put to a vote has expired, the next logical step would be to archive so that it will be made part of our records. It is the position of the chair, subject to the wisdom of the plenary, Your Honor, that given the Supreme Court decision that the Senate never acquired jurisdiction over it, that the proceedings and the articles of impeachment were null and void ab initio. Indeed, there might not even be anything to dismiss, and the procedure would be more properly to archive, similar to what we have done in the past, so that these proceedings will still be made part of the Senate's records. But we will cross that bridge once we put it to a vote, Mr. President.
I go back to my previous question, Mr. President. Anong gagawin natin sa motion to dismiss? How do we deal with it? We are in plenary as a legislative body. We're not an impeachment court. So yun ang tanong ko po, Mr. President. Yun ang essence ng aking parliamentary inquiry.
The predisposition of the chair is what I stated, but subject, of course, to the wisdom of plenary. Maybe here from Senator MATCOLETA with respect to his ideas, given that he is the proponent
Mr.
of the
President,
motion.
it is true that the motion to dismiss is not part of our rules. But it is part of our rules po yung pagiging suppletory application po ng rules of court. In the rules of court, yung korte po can motu proprio dismiss a case kung wala pong jurisdiction. And considering that the rules of court has become part of our rules, that's why I use the motion to dismiss. Pag wala pong jurisdiction, halimbawa, sa isang korte, collection case po ito, 5,000 pesos po yung pinal niya, dinismiss po ng court kahit hindi pa sumagot yung kalaban, Mr. President, kasi ang jurisdiction po ng korte hanggang 3,000 lang. Ganun po ibig sabihin nun. Minsan po, wala pong, hindi po verified yung complaint, dinismiss. Sa motu proprio, talagang dinidismiss. Paano po kaya kung sinabihan pa nga na the Senate didn't acquire jurisdiction over the case? Mas lalo po sigurong dapat nating panindigan na talagang i-dismiss na po natin, Mr. President.
Senator Lacson is recognized.
Again, I refer to our rules, Mr. President. Wala rin po ako makitang suppletory application sa rules of the Senate pagdating sa plenaryo. Pwede pong gamitin ito sa mga committee hearings, inquiry in aid of legislation. But we are not there. We're here in plenary. Maski po basahin natin na 100 beses ang ating rules of the Senate, wala pong suppletory application sa ating rules. Thank you, Mr. President.
The point of Senator Lacson, so far as that is concerned, is well taken. Senator Pangilinan.
Just on the point of suppletory, the rules of court being suppletory. Mr. President, the rules that are suppletory presupposes that there are no rules of the Senate or the Senate impeachment court. In other words, in the absence of a standing rule, or provision of either our Senate rules or the Senate impeachment court rules, then we refer to the rules of court as suppletory to our rules. But in this case, the Senate impeachment court has a specific rule, resolution number 39. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day until final judgment shall be rendered, and so much longer as may in its judgment be necessary. In other words, as an impeachment court, of course, not as a Senate in plenary, but even that is now being debated because this representation believes the sole power to try and decide impeachment cases is the impeachment court and not the Senate in plenary.
Oh, ha?
Mr. President.
Ika eh. Ika.
Majority Floor Leader.
Mr. President, next to interpolate, Mr. President, on the list of this representation is the distinguished gentleman from Taguig and Pateros, no other than Senator Alan Peter Cayetano. I move that he be recognized, Mr. President.
If I may, Mr. President, with the indulgence of the good gentleman from Taguig and Pateros, yung akin po ay susog dun kay Senator Lacson ng mga punto.
But Your Honor,
It's not an interpellation yet, Mr. President. I follow up point to the point of Senator Lacson. If the SP
Lady
and the gentleman, thank you, Mr. President, and with the indulgence, as I said, of the good gentleman from Taguig and Pateros, nabanggit na rin po, Mr. President, pareho ni na Senator Lacson at Senator Pangilinan, yung usapin ng tayo ba, Senate or Senate impeachment court ba? So this is a point of inquiry, actually, a brief point of inquiry, Mr. President, related to the motions at bar now. The question presented to the body is related to an ongoing impeachment case, which is within the jurisdiction of the impeachment court. Should we not first have the newly elected senators take their oaths as senator judges and convene as an impeachment court? I note, Mr. President, that the Supreme Court decision is not yet final. As colleagues have mentioned, a motion for reconsideration has been filed by the House of Representatives, and the court itself, the Supreme Court, has given 10 days for the Vice President to comment. So yung point of inquiry ko nga po, Mr. President, hindi po ba dapat pasumpain na muna ng presiding officer with us convened as an impeachment court yung mga bagong halal na senador para makapag-convene po tayo bilang impeachment court at i-treat yung mga motions at bar. Salamat po, Mr. President.
noted and entered into the records. What is the pleasure of the Honorable
A very quick intervention. Very quick, Mr. President.
Pangilinan? Yes, you may proceed, sir.
Yes, Mr. President, and we place this on record after reading the ruling, the decision of the Supreme Court. Mr. President, the Supreme Court referred to the Senate impeachment court repeatedly. And therefore, it is the Senate impeachment court that was also impleaded. It is the Senate impeachment court that may, if it opts to, file a motion for reconsideration. And therefore, this motion to dismiss, we believe, should be forwarded to or tackled by the Senate as an impeachment court.
Your Honor, just on that point, the parties mentioned in the case is not the Senate impeachment court, but the Senate. And the dispository section of the decision makes mention also of the Senate. If I may quote, consequently, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. That's the decision of the court in Duterte v. HOR.
Mr. President, and we will go back to the earlier manifestations of...
Mike, please.
We will go back to the earlier manifestations of the minority leader. Yes, the Supreme Court ruled that we have no jurisdiction. Yet, the decision is flawed in terms of the facts on procedure, the one-year bar, and on due process. This is at least, of course, our assertion. And therefore, should we not wait for a motion for reconsideration to be resolved before we proceed and vote on the matter that has removed from the impeachment court jurisdiction? Should we not at least assert the power and the prerogative under the Constitution of the Senate impeachment court in terms of the exclusive jurisdiction, number one, and the sole power to try and decide?
That is what we will be deciding and voting upon this afternoon, Your Honor.
Thank you, Mr.
Senator
President.
Cayetano is
Yes,
recognized.
Thank you, Mr. President. The distinguished gentleman, Senator Marcoleta from Tarlac and Senador ng buong bansa. Sir President, initially I wanted to speak pagbotohan na po. But very interesting po yung question na bringing up ni Senator Lacson. But aside from that, Mr. President, masyadong mabigat yung crossroads na hinaharap ng ating bansa. And remember, assuming we do nothing today, I am 101% sure that on February 6, 2026, an impeachment case will be filed against the Vice President. Maybe against other impeachable officers too. So I think it is very important that mahimay natin yung desisyon, yung sentimento ng institusyon na to, mailabas hindi lang sa social media at sa traditional media ang mga puntong nagsasaliwa, meaning pong parang hindi nag-uusap eh. So at least here we disagree, but whether we listen to the minority leader or to Senator Marcoleta, we agree to listen to each other and to examine each other's points. So I just like a few minutes on some very important matters. Let me start by the accusation that because of this decision, masyado nang mahirap at wala nang mai-impeach. So may I ask Senator Marcoleta if he would give me the honor of asking him a few questions and allowing me to interpolate on 2 or 3 topics. The first one is whether or not naging imposible na mag-impeach under this decision.
The gentleman may proceed if Senator Marcoleta will so allow it.
Yes, Mr. President.
Mr. President, sabi po nung iba, imposible na daw mag-impeach ngayon dahil sa desisyon. I see the decision before you. I approached you last week. You've been studying it. I see your radio program. Mukhang 10 beses mo na nabasa yung desisyon. At apparently, Mr. Senator, you also listen to criticism. So kung ano rin yung sinasabi ng iba, pinapakinggan mo rin. In your view, may I take note first, Mr. President, that I am glad that the Senator made a distinction na he is for the rights of everyone. He was adopted by PDP and ran with a particular party, but he is not a member of the Duterte bloc. Am I correct there?
Technically speaking, Mr. President, I am not a member of the PDP, but I admit that I was adopted and I ran in unity with some of the parties of the PDP candidates at the
The
time.
point I'm going at is like, I was a cabinet member in the Duterte administration, but I have not talked to the Vice President. I ran as an independent in 2022, so I speak now as a senator and not as a partisan. I assume the same, Your Honor.
Yes,
That
Mr. President.
you're giving your own personal opinion as Senator Marcoleta, not as a partisan. Of course, I assume that for everyone here, no, regardless of our position. So, Mr. Senator, sa iyong paghimay ng desisyon, sa tingin mo ba imposible na ngayon mag-impeach ng isang impeachable officer?
Hindi po, Mr. President.
Hindi pala eh.
So, naging napakahirap ba mag-impeach ng isang officer?
Mahirap.
Hindi ko po alam kung bakit mahirap po sa kanila, Mr. President. Ang importante lang po ilagay lang po sa tamang proseso eh. Napakasimple po kasi nung kanilang mga tuntunin, iniisip ko, sundin lang yung mga tuntunin. Ang problema po, isa man sa tuntunin, wala pong sinunod eh. Kaya po humirap ng humirap para sa kanila.
So, Mr. President, I'm glad you mentioned tamang proseso. I think the way the Supreme Court said it in page 95 of the decision, there is a right way to do the right thing at the right time. The problem, Mr. President, is sinasabi po nung iba, may decision na sa former decisions, meron ng definition ng initiation, and many of us here were not mere spectators there. I mean, Senator Soto, I think, was in the impeachment court, di ba, of Senator Estrada, Senator Laurentu. Senator Kiko was still on the, we were together kay Senator Corona. Senator Cheese and I and Senator Miggs were in the House during the prayer 1/3 to the Senate articles of impeachment, di ba? So, hindi po tayo stranger sa mga pangyayaring ito. Ang punto ko, Mr. President, Senator Marcoleta, kung hindi nagsabi ang Supreme Court ng specific na dapat sundin, pwede kong ma-interpret na baka naman masyadong mahirap. Baka naman kahit anong i-file kung gustong protektahan, hindi na siya ma-impeach. Paano na yung accountability? But is it true, Mr. President, that on page 93 of the decision, the Supreme Court actually narrated what has to be done for a valid impeachment complaint?
Yes, Mr. President.
Allow me to read. 1, the draft article of impeachment or resolution should be accompanied by evidence when made available to members of the House, especially those who are considering its endorsement. 2, the evidence should be sufficient to prove the charges in the articles of impeachment. 3, the draft articles of impeachment and their accompanying evidence should be made available to all members of the House of Representatives, not only to those who are being considered to endorse. Impeachment is an act of the entire House, which requires a qualified minority of only 1/3 of its members to be transmitted to the Senate. However, the House of Representatives is a deliberative assembly where each member should be allowed to represent the views of their constituents. Let me stop there first. Mr. President, may problema ba yung number 1 na yung articles of impeachment kailangan may ebidensya?
Wala pong problema doon, Mr. President.
Hindi ba ho baliktad? Kung walang ebidensya, may problema.
Tama po.
Kasi kung walang ebidensya, ano yon? Tapon mo sa Senate, bahala na si Batman. So precisely tama ang Supreme Court that even if 1/3 endorse or file, dapat may ebidensya na. Let me go to the second part. The evidence should be sufficient to
Hoy David, ikaw lang nanonood dyan, ha? Ikaw lang nanonood dyan. Vlog ko to, baliw.
prove the charges in the article of impeachment. Mr. President, tama po ba na iba po yung sufficiency at iba din po yung quality or yung burden of proof, di ba?
Opo.
So halimbawa po sa piskalya, hindi po kailangan sa piskalya beyond reasonable doubt.
Probable.
Kailangan lang that there is probable cause that a crime was committed and there is probable cause that the accused committed that crime.
Yes, Mr. President.
So in the same manner, hindi sinasabi dito sa 2 na kailangan mo ipresenta sa mga congressman lahat ng testimony, lahat ng ebidensya. Ang kailangan lang, if you assume the evidence to be true, it will be enough to convict.
Tama po.
Because if not, then sayang lang ang oras natin sa Senate. Kung may articles of impeachment ka, walang ebidensya or may ebidensya pero yung ebidensya is not sufficient to prove the charges, either the Senate will be a kangaroo court and convict without evidence or we will be wasting our time. So wala rin problema sa number 2, Mr. President.
Wala po, Mr. President.
Number 3, ang sinasabi lang ng number 3, kahit na pumirma yung 1/3, kailangan ipakita pa rin sa lahat ng Kongreso. Isa po sa hinanakit po yun nung bata ako dahil ako po'y payat nun at hindi katangkaran. Parati akong saling pusa sa basketball, baseball, volleyball dahil hindi po ako ganong kagaling sa sports. Sa Congress ba, hindi ba tamang rule to? Na kahit wala ka sa majority, kahit wala ka sa qualified minority, kapag ka may impeachment, merely being elected as a representative of the district or of the party list, dapat ipakita man lang sa iyo yung articles of impeachment at saka yung ebidensya.
Tama po kayo, wala man lang po akong nakita sapagkat ako po hindi sinali sa pakakitaan ng...
So naiintindihan niyo po kung paano maging saling
Hindi ko nga po alam na meron na po pala, hindi man lang kami binigyan eh. Kaya nung tinanong ko po yung aking mga kasama,
Guys, ang ebidensya nasa social media, ha? Open na open ang ebidensya sa social media. Ano tong sinasabi ng mga senator na to na hindi nila nakikita ang ebidensya? Yung bank account nga nakatuyang-yang na, nakabuyang-yang sa social media. Ano tong sinasabi nitong ebidensya hindi nila nakikita? 'Di ba? Sinungaling. Yung mukha ni Marcoletang unggoy, sinungaling.
wala bigyan nyo nga ako ng kopya para mabasa ko. Wala rin kami. Paano nyo pinirmahan? Hindi naman namin binasa nung pinirmahan na. Basta meron lang binigay ng mga signature pages. Doon lang kami pumirma.
Well, Honor, as chairman of the Senate Blue Ribbon Committee, is not a saling pusa here in the Senate. In fact, you are an esteemed neophyte with a very powerful committee. So, again, number 3 is just a simple walang saling pusa rule, which is very good. Number 4, respondent have the opportunity to be heard on the draft articles of impeachment. Hindi ko na po babasahin dahil mahaba, pero basically ang sabi ng Supreme Court dito, hindi naman kailangan pumunta doon ang Vice President. Pwedeng through pleadings. Meron po bang masama dito, Mr. President, na kapag may na-impeach, bigyan man lang siya ng kopya at pasagutin muna siya sa House bago siya pasagutin sa Senate? May masama po ba dito?
Wala pong masama, Mr. President. Ang totoo nga po,
Ay, pinasagot na siya. Pinapunta na siya sa TRICOM, o kung ano man yun. Di ba hindi nga siya nasagot? Kaya impeachment na talaga siya. Hindi siya nagsasalita. Alright? Di ba tinawag na siya? Inimbitahan na siya. Anong sinasabi nito ni Cayetano? Sa Senado.
sinasabi nga na dapat i-repair po lahat ng impeachment complaints kahit na yung pinirmahan ng 1/3 o higit pa, i-repair sa Committee on Justice. Yun po ang paraan siguro para magkaroon man lang ng pagkakataon ng Vice President kahit na by pleadings lang, makasagot siya.
Yeah.
Pero hindi nga po ibinigay.
Before I go to number 5, just because I like your answer, Mr. President, one thing that guides me, no? So I've in coming to my decision with this, I follow 2 books. One, the Bible, which is of course a covenant between God and people, tayo, and the Constitution, which is a covenant among the Filipino people and the government, no? Alam mo, both books talk about due process. Ang Panginoon, nung kinain ni Adam at Eve yung prohibited fruit, nagtanong muna siya, ba't kayo nagtatago? Hindi nag-accuse, nagtanong muna, pero alam na ng Diyos. So ang ibig lang sabihin ng due process, sabi ng desisyon ng Supreme Court, magtanong ka muna bago ka humusga. So Mr. President, I was thinking, what if naging masyadong emotional yung eleksyon ng huli? And one-third of members of Congress ay naging anti-administration, at ang kinahaharap natin ngayon ay isang impeachment labang kay President Marcos, at pag siya'y na-impeach, magiging presidente si Vice President Sara. I wonder if all of us in this room and out of this room will still have the same paninindigan. I hope I will. I'm not judging. I am just saying, Mr. President, what helps me is those 2 books, but also to put myself in the opposite side, to put myself in that position. What if, so I'm looking, I see my good friend, former Senate President Subiri, shaking his head. So, natanaw ko tuloy si Senator Kiko. What if Vice President Lenny and Senator Kiko won in 2022? And what if ang ini-impeach ngayon ay si Senator Kiko? I hope yung decision ko to support this decision would be the same.
Tama
Because
po, dapat walang pagkakaiba.
Wala saan pagkakaiba. So number 5.
Hoy, kayo dyan. Bakit? Kayo ba nakatapos din? 'Di ba sinabi na nga ni Ping Lacson kanina na wala sa Constitution rule ang dismiss ng impeachment. Naiintindihan nyo ba yon? At eto si Cayetano, sinungaling yan eh. Iboboto nyo ako kasi bibigyan ko kayo ng tagte 10K. O ano ngayon, nabigyan kayo? Ha? Tapos eto nagsasalita pa, di ba nakakagigil yung noo?
A reasonable period of time determined on the basis of complexity of charges must be given to all members of Congress. Kasi lumalabas po, yes, tama si Senator Soto, ibang mode yung 1/3. Pero lumalabas po mismo sa pleadings, mismo sa sinabi ng House of Representatives, wala pang 3 oras. Yung
Wala po.
ibinigay sa mahigit 200 na pumirma, samantalang ang complaint is a few hundred pages. Tama po ba?
Mahaba pong pahina lahat ng sinabi sa akin, Mr. President, at hindi po nila na kayang basahin sapagkat wala nga silang kopya. Humihingi po sila ng kopya bago pumirma, ngunit wala pong ibinigay. Yun po yung sinabi sa akin ng mga ilan sa aking mga kasamahan doon.
Yung number 6 po, Mr. President, madali kasi kailangan yung impeachable act is an act done while they were in their present office. So wala naman pong problema dyan. Meaning, kung may nagawa si Senator Cruz nung konsyal pa siya, pero ngayon Vice President na siya, hindi naman siya pwedeng impeach base sa ginawa niya nung konsyal siya.
Tama po.
So madali po yon. Number 7, at the very least to accord the opportunity to be heard under the requirement of due process in the procedure under Article 11, Section 3, Paragraph 4, after the draft articles of impeachment and required proof arrived at. Letter A, the House of Representatives should provide a copy of the draft articles and its accompanying evidence to the respondent and give her an opportunity to respond within a reasonable period. May problema po ba dito?
Wala po.
Kapag ka ganito kabigat, natatanggalin mo ang isang impeachable officers, tama po ba yung surprise?
Hindi po.
Parang, eto yung wag mo nang tignan, 1/3 naman kami, sa Senado ka na, sa Senado ka na mag-reply.
Surprise? Ano surprise? Sira ulo ka ba? Kaya nga...
Letter B simply states that all members, again, it's the walang saling pusa. So, Mr. President, in other words, it is not true that it is now too difficult. Sundin lang yung page 93, 94, whether it's February 6 for the Vice President or if anyone wants to file an impeachment against anyone, magagawa to at any time.
Tama po, Mr. President.
Let me reverse my question, Mr. President. Dapat ba maging madali mag-impeach ng isang officer? I'm asking, of course, your opinion that I value, Mr. President.
Talaga, grabe. Grabe.
Depende po sa
Grabe.
ini-impeach na opisyal. Pero kinakailangan po hindi dapat magmadali. Kaya dalawa po kasing bagay yun eh. Kailangan po siyang mapagbigyan ng due process niya.
Mag-iisang
At
taon na nga.
gaano man po karami yung ebidensyang inaharap sa kanya, bigyan natin siya ng pagkakataong makasagot. So maaari pong mahirapan ng konti, tumagal ng konti. Ngunit kailangan po natin ibigay lahat ng proseso sa ini-impeach at sa mga nag-i-impeach.
I value your answer on due process, Mr. President, and that's my second point. But if you would just also accept, or maybe I can put on record, I'm of the personal view, hindi dapat maging madali mag-impeach ng isang impeachable officer.
7
Bakit
months
po?
na.
Unang-una, iilan lang po sila sa ating bansa.
February pa yan,
Ombudsman,
Roy.
member of constitutional commissions, President, Vice President, Supreme Court. Hindi dapat madali dahil it's an extraordinary remedy in extraordinary circumstance not to penalize them, but para protektahan ng ating bansa at para nga po alisin sila sa equation if they will damage our country. So, the difference po with this impeachment sa iba, at least the impeachment of President Estrada, President Arroyo, and again, may I be sensitive especially to my friends here, who are of that administration, was with us, against us, or like Senator Jingo and Senator JV. Yung feeling kasi doon is that if there was another day na hindi na impeach, magagamit yung opisina na yon. Kasi presidente pinag-uusapan. Ganon din sa Chief Justice, na habang nandun ka, ma-influensyan mo yung korte.
Ay, hindi namin
Pero pag
tatanggapin.
pinag-uusapan mo Vice President ngayon, wala naman siyang hawak hawak na departamento. Wala siyang hawak na agency. Wala namang police, militar, NBI, Coast Guard, whatever under sa kanya. Yes, we should hold her accountable kung may ginawang mali. Dapat i-impeach pag may ginawang mali. Pero it's not true that today and tomorrow matters that much. Because wala naman siyang opisina na magagamit not only to cover her tracks or to damage the country. Diba? In fact, I doubt kung walang perpetual disqualification yan, baka iba ang suma natin ngayon. But I don't want to go to the political aspect. The point I want to make, Mr. President, is para tayong nag-Goldilocks. Pag gusto natin yung i-impeach natin, so nung time na yon na gustong i-impeach si President Erap, padaliin natin. At kung hindi, walk out tayo. Kung kakampi mo si GMA, pahirapan natin. Kung kakampi mo si Duterte, pahirapan natin. Diba? So, in that point, I see why the Supreme Court, they made a statement nag-statement sila about history. Sabi ng Supreme Court, ito po, sa page 94, we understand our history. We have learned that in the past, momentary desires to do what is convenient and concede means to ends have inadvertently created precedents that weaken the succor of law for those who dissent, or those that are society's margins, or those who have fallen out of grace from the powers that be. We have learned that the clash of political interests in the past, often disguised by noble intentions, have obscured the need to address the real problems of corruption, inequality, poverty, and disempowerment faced by our people. Kung ito lang po ang sinabi nila, Mr. President, sasabihin kong hindi ba namumulitika yung korte? But sinabi nila to after page 93 na inisa-isa nila paano mo i-impeach So parang ang tinuruan na ang Senado at saka House, gusto nyo impeach ang Vice President o sino man, sundin nyo lang to. Wala na kayong problema. So I think in that sense, Mr. President, it's a balanced decision. Ang question, Mr. President, yung tanong ni Senate Minority Leader, former Senate President Soto, operative fact, Mr. President. Mr. President, may I venture to answer the question of Senator Soto nung tinanong niya, ano to? Diba? Ano to yung nag-robe, etc. Nasagot na po kasi ni Sara Geronimo yon. Nung sinabi niya kay Coco Martin, there was never an us.
There was never an us.
There was never an us. Sinabi kasi ng Supreme Court na void ab initio to. But I have a reason, Mr. Minority Leader, former Senate President, and Senator Ping, why I bring this up. Because I agree with Senator Ping na ano ang i-dismiss natin. Because ang sinasabi ng Supreme Court, and that goes to my last point, for your consideration, Senator Marcoleta, sabi ng Supreme Court, there was never an us, ibig sabihin, void ab initio. So wala tayong i-dismiss.
Di tumigil na kayo.
So theoretically, if we do not do anything today, we are following the Supreme Court decision. Except, that's why I'm agreeing with you. So agree with me when I'm agreeing with you, Mr. Senate President and Senator Ping. However, human nature is that if we do not do anything, people will say it's pending. And we do have the 1 year one filing bar. So the Constitution did not intend that every single day of your life as Ombudsman, as Vice President, President, may nakatutok sa yung impeachment. So it is also fair to the Vice President that we dispose
Nakasampa na ang
of
kaso kay
this.
Sara. Huwag kayong mag-alala.
The question now is, if it is void ab initio, why did the Supreme Court not apply the doctrine of operative fact? In my research, two reasons. One, hindi po bringing up ng House of Representatives ito. Bringing up po to ng House of Representatives later on in the MR. Number two, there is a rule that kapag ka magkakaroon ng injustice or may ma-oppress, hindi pwede yung operative fact. So since my finding, please correct me, Senator Marcoleta, if I'm wrong. Since my finding po ang Supreme Court na sinircumvent yung 1-year bar, hindi ka ngayon pwede mag-operative fact kasi para mo ni-reward ngayon yung circumvention. Am I correct sa
Yes, Mr.
perspective?
President, because the doctrine of operative fact is based on equity and fairness. Wala pong equity talaga eh. Hindi po sinunod ang mga tuntunin. So, sa umpisa pa lang, nagpalusot na, kaya hindi po pwedeng gamitin yung operative fact.
I see former Secretary Jeremiah Bellica in the crowd. Sa ease of doing business na si Majority Leader and si Senator Ping, I think were the sponsors, di ba, or the authors of the law. I don't know kung, ang alam ko, covered ang Congress dun eh. So kapag ka 10 days, at kasi ministerial yung sabi ng Supreme Court eh. Kapag ka nag-file ka ng impeachment, yung 10-day, 3-day, ministerial yon. So even if you do not consider it archived, if you apply the ease of doing business law that Secretary Jeremiah Bellica used to very much push in government, you would come to the same conclusion. My point is, Mr. President, we'll never come out with a perfect decision. People will disagree. That's why I agree with the statement of the IBP na ang kailangan sa Constitution ay hindi agreement, kung hindi adherence. The North and South of the United States did not agree on slavery. That's why they fought a civil war. Because they had to see who will adhere to this Constitution, who will treat this piece of paper as a living soul and a covenant of this country rather than just a piece of paper. And grabe po ang devastation sa United States. Buti po tayo nagdidebate lang. Buti po tayo yung dugo ng ating mga bayani ay minsan lang po inalay at ngayon nagdidebate na lang tayo sa desisyon na to. Pero kung hindi natin susundin ang Supreme Court decision and we will court a constitutional crisis, we will tear the Constitution apart because, Mr. President, this is going to second to the last question. May option ba tayo not to follow the Supreme Court?
Wala po, Mr. President.
Wala nang fourth week, no?
So it's for academic discussion and for criticism, for enlightenment, and trying to influence the court na masama decision nyo. In accordance, I respect the opinions for those who think na masama yung decision. But in actuality, as an institution, we have to follow, hindi po ba?
Tama po, Mr. President.
Is the gentleman a member of the Commission on Appointments?
Wala pa po yatang ini-elect.
Hindi, kasi may decision ng Supreme Court kung paano hati-hatiin yung membership ng CA. Kung hindi rin natin susundin yung decision ng Supreme Court sa impeachment, wag na rin natin sundin sa CA. What about sa sweldo ng mga senador? Diba, sabi sa konstitusyon, sa mga batas, hindi tayo pwede magpasa ng batas na makikinabang tayo.
Tama po yun.
So kung disagree tayo, wag na rin natin sundin dahil mas mataas na sweldo yon.
Kailangan po kasi palagi nating isasaalang-alang kung anong sinasabi ng desisyon ng Korte Suprema at hindi yung sarili po nating nilalayon o sarili nating interes.
Correct po ba? Especially when we disagree. Madali kasi magsang-ayon pag we agree eh.
Tama po.
Marami magsasabing nag-uusap tayo through microphone but we agree on many things. But mas mahirap when we disagree.
Tama po.
Mr. President, so since we disagree slightly on dismiss, would the movant, the distinguished senator, consider na ma-amend yung motion that the Senate obey or follow or anong tamang salita na acceptable sa minority, the Supreme Court decision? Because if the motion is to obey the Supreme Court, so if the Supreme Court reconsiders, the motion still carries, then we will follow. If they don't, we will still follow. And right now, sabi naman nila, it is immediately executory. So as far as I'm concerned, it doesn't exist. But I agree with the gentleman, there's some action that is wanting eh. Kung hindi, Kung hindi, it's there floating in the air. Anyway, I'll leave that as a question. There might be some people who want to interpolate, Mr. President, but may I offer that solution? We are allowed to amend, to propose an amendment to any motion if the movant agrees.
I am amenable to an amendment, Mr. President, like moving it to send it to the archives. Like we will have the same result if that is the case. And I will be pleasing Senator Soto if I do that.
What is the pleasure of the Honorable Soto, the distinguished minority floor leader?
Thank you, Mr. President. It grieves my heart to disagree. I think I'd rather call for the previous question, a motion to table. It has the same effect, and you can bring it up anytime, but we did not say that we did not follow the Supreme Court decision. It will not say that we archived as the interpretation of the Supreme Court is, kung ano yung word ng archive. Iba yung archive nila eh, hindi pa nga adjourn, archive na sa kanila eh. Hindi ba? Hindi pa tapos yung session eh. Hindi naman ganun ang archive sa atin. Sa kanila ganun. Iba yung rules ng Congress eh. Iba yung kaysa sa rules nila eh. So, hopefully, baka pwedeng we can find a middle ground between the proposal of Senator Alan Cayetano and my motion to table, which has a higher precedence than the motion to dismiss.
But Mr. President, that is not consistent with the immediate character of the decision. The decision says it is immediately executory. A motion to table, hindi po immediate yun eh. Kaya sabi nga ni Senator Cayetano, somehow there should be some action. The people are waiting for some kind of a closure before this chamber. Because that particular decision is directed to no one but to the Senate, Mr. President.
Sir President.
Before the chair recognizes any member, the parliamentary status is that a motion was made by the Honorable MATCOLETA, which he is willing to amend, and a higher order of precedence motion was made by the Honorable Minority Floor Leader. Both are pending, and to afford time for both the Minority Leader and the original movant to perhaps consider and find a compromise as agreed upon earlier, can we proceed with the interpolations and interjections, manifestations, if you will, of the other members who had manifested to so interject and make known their position through a manifestation or interpolation?
Yes, Mr. President. Therefore, I withdraw the call for the previous question, and then allow that to proceed. But then again, just a point of information for for our colleagues. The Supreme Court has just received a motion for a TRO for the Senate not to take up this particular case. It was filed yesterday by the former Associate Senior Justice Tony Carpio, also Ombudsman Conchita Carpo Morales, Commissioner Heidi Mendoza, religious leaders, former military and public servants, Michelle Magno, students and the youth and the academy. They have filed a TRO with the Supreme Court, and we are awaiting something to that effect. It might come out today, and then we are again inuunahan natin. So hopefully, yes, we can proceed, Mr. President.
Thank you, Minority Floor Leader. Your manifestation is duly noted. Senator Cayetano.
Sir President, let me agree
Wind up.
let me just agree with both you and the Minority Leader. And of course, thank Senator Marcoleta for his openness. Ang intention ko lang naman po in proposing an amendment, wala pa yung actual words, no? But Mr. President, kasi kung pwede, pag bumoto tayo, dahil mabigat po yung pagbobotohan natin at most of us have dug in already sa legal opinion natin sa boto natin. So kung mali ang framing kung ano pagbobotohan, mahihirapan din tayo lahat. So meaning I don't mind if I vote for or against the proposition, at least malinaw kung anong pagbobotohan ko. So like I would vote to follow the Supreme Court decision. I'm thinking whether I'll vote to dismiss because the Supreme Court said it did not exist, void ab initio. But I don't want to vote against it because if I vote against it, it is live. And precisely the Supreme Court said immediately executory. No? So let me yield the floor para dun makapagtanong yung iba. But I'm hoping some of us can come up with language that will be acceptable. We might not have a unanimous vote, but at least klaro kung anong pinagbobotohan natin. Thank you very much, Senator Marcoleta.
Mr. President, just a point of information.
Senator Pia Cayetano is recognized for her point of information.
Yes, thank you, Mr. President. I'm happy to be corrected. We have on the floor, I don't know, maybe 5 or 6 previous majority floor leaders. Senator Alan was a majority floor leader. The minority floor leader was Senator Soto was a majority floor leader. Senator Kiko was a majority floor leader. Senator Subiri, former Senate President, was also a majority floor leader. I hope I didn't forget anyone. Lauren was a majority floor leader. So on that note, I just want, so again, I'm happy to be corrected, but the rules, to my knowledge, do not limit us to a particular kind of motion. Rule 31, the title is Precedents of Motion, so it lists the motions that take precedence. Rule 32 is the privilege motion. It doesn't mean that we cannot have a different motion. So just put that on the table so that those who want to be creative can continue this discussion later on when we get to that point that we're deciding if we will rephrase, if we choose to look for a more appropriate wording. But I'd like to include this in everyone's for everyone's consideration, that there doesn't seem to be a limitation on what kind of motion we can present to the body. Thank you.
Thank you very much, Senator Cayetano. Mr. President, at this juncture, may I move that we recognize the distinguished gentleman from Davao, Senator Bato de la Rosa.
Senator De La Rosa is recognized. What is your pleasure, sir?
Thank you, Mr. President. I just would like to make a clarification, Mr. President, that it's very clear to me during our caucus, we have agreed that today, on this date, we are going to tackle this Supreme Court ruling, and we have to debate on this, and we have to decide on this today. It was not part of the agreement that whenever the House of Representatives file a motion for reconsideration, ay ma-install yung ating plano to decide today.
Nangingintab si Bato.
So, bakit nagbago yung usapan, Mr. President? I'm just asking.
Your Honor, the Senate is a collegial body and decides everything by dividing the House. The current parliamentary status is that we have 2 motions that have not yet been acted upon. One is precedence over the other. Pinahintulutan ng dalawang movement na magpatuloy muna yung pagdedebate. So darating po tayo sa punto, matapos ang debate, na pagbobotohan natin yung dalawang motion po na yan. Ayon sa precedents ng rules natin. Majority Floor Leader.
Mr. President, just very quickly.
Mr. President,
Very quickly.
Is this already your...
Just an interjection on the point raised by Senator De La Rosa.
Mr. President, if I may appeal, Mr. President, to distinguished gentleman from Pampanga, Mr. President, because next to interpolate is the distinguished lady from Iloilo, Mr. President, Senator Risa, and then it's his turn, Mr. President.
Just a quick manifestation.
The gentleman may proceed for his quick manifestation.
Because it has been referred repeatedly about what we agreed on in the caucus. Mr. President, we agreed to decide on this matter. And if the decision is to lay it on the table, that is a decision of the Senate in plenary. In other words, we didn't agree on deciding that we will decide on a motion to dismiss. We didn't agree that we would decide on holding it in abeyance. We said we will decide.
Your Honor, that's precisely what the chair said. We will be deciding on these pending motions at the proper time after debate. Senator Antiveros is recognized for her interpellation
Debate
and
lang yan, pero
interjection.
mamaya,
If
motion
Senator
to dismiss na yan.
Marcoleta so desires.
Yes, Mr. President.
Si Robin, dapat pagsalitain.
Salamat po, Mr. President.
Kwento niya na naman yung pagkakulong.
In lieu of an interpellation of the good gentleman from Tarlac, I will be seconding a motion, Mr. President, preceded by a brief manifestation. Earlier, Mr. President, Senator Marcoleta said he refuses to speculate on reversal. But the good gentleman's own position is based on his own speculation that the SC will not reverse its decision. A tabling of the motion to dismiss, which is what I will second in a few minutes, Mr. President, a tabling of the motion to dismiss by the Senate today is not defiance of the Supreme Court. Wala pa nga po kasing final na decision. Kahit ang Korte Suprema po, iniintay pa ang comment ng VP. That is why I will be seconding the motion of the Minority Leader to table the motion to dismiss the impeachment complaint until the decision of the Supreme Court has attained finality. Tama po, we should exercise extraordinary prudence in this matter of transcendental importance. Still, I also wish to also take this opportunity to express my thoughts at this crucial
Tama ka
moment
dyan,
for our
Abner.
chamber. Mr. President, I agree and I continue to respect the Supreme Court. Hindi po magbabago iyan. But Mr. President, hindi naman po ibig sabihin ng respeto ay pananahimik. Lalo na kapag inisip natin kung gaano kalaki ang nakataya dito. Magkaiba rin yung rumerespeto at yung bulag. Kaya naman, I will not be choosing silence, nor will I be turning a blind eye in the face of clear and unmistakable injustice. I am encouraged by the words of brave professors of the UP College of Law who in 2010 issued a sharp critique of a Supreme Court decision, Vinuya versus Executive Secretary, which said, the
Tama
court
ka
cannot
dun eh.
regain its
Yes.
credibility and maintain its moral authority without ensuring that its own conduct, whether collectively or through its members, is beyond reproach. So, in the context of the SC decision, Duterte versus House of Representatives, I believe we need to shed light on some concerns which former justices and constitutional framers themselves,
For Vice
some of whom are
President
here
talaga.
this afternoon, Mr. President, have underscored. Una, the Supreme Court decision was based on critical factual errors. At binanggit na rin po ito ni Minority Leader. And this has since been pointed out by no less than retired Senior Associate Justice Antonio Carpio. For example, the decision said that the February 5 impeachment complaint was transmitted to the Senate without a plenary vote in the House. A simple check of the record, specifically House Journal number 36, shows that this is false. Walang haka-haka. Those official records are plain for anyone to see. Sabi tuloy ni retired Chief Justice Renato Espuno, na siyang chairman ng Philippine Constitution Association, the Supreme Court was faced with a famine of facts necessary to make a decision invulnerable to constitutional assaults. Pangalawa, actions already taken under a prior and valid interpretation should be recognized as legally effective.
Mas okay pa nga
Yan
maging
naman
vice
ay
to
mula
eh,
kay
si
retired
Riza.
Justice Adolf Ascuna. The House of Representatives was operating under the regime of the legal doctrines in Francisco and Gutierrez, which held that the initiation of impeachment proceedings begins from referral. Kung unconstitutional pala na sundin ang legal doctrines,
tama yan.
in the words of Justice Ascuna, that is legally unfair. Paano nga naman unconstitutional kung sinunod lang nila ang patakaran ng mismong Korte Suprema? Dagdag pa po sa isang desisyon nitong 2020 lamang, Madreo versus Byron. Sabi ng Korte na kung may pagbabago sa doktrina at interpretasyon ng batas, dapat prospective ang aplikasyon nito. At ang pangatlo at huling punto, mistulang nadagdagan ang requirements sa proseso ng impeachment na hindi naman nakasaad sa ating saligang batas. These new limitations, Mr. President, are not found in our fundamental law. Wala yan sa konstitusyon at kontra yan sa accountability. One disturbing example, sabi ng desisyon, Kailangan daw na isumite na ang bawat ebidensya laban sa opisyales sa pag-file pa lang ng complaint sa House. Dapat ba naka-attach na ang bawat bank slip, public record
Oo nga.
o testimonya ng witness na ihaharap kahit wala pa silang proteksyon ng Senate Impeachment Court? Ang tanong tuloy ng marami, realistic ba yan? Paano kung ang impeachment ay laban sa mataas na opisyal na kayang-kayang magtago ng ebidensya o manakot ng mga potential witness?
Tama.
Bakit humaba yata ang checklist ng proteksyon para lang sa impeachable officials? Samantalang ang taong bayan na nagtatanong, na naniningil ng pananagutan, sila pa ang pinahirapan. Sila pa ang nadagdagan ang requirements. Ayon sa Korte Suprema, an official facing impeachment does not stand to lose fundamental constitutional rights such as life, liberty, or property. Hindi buhay, kalayaan, o pag-aari ang inihahabla sa impeachment. Kung ang usapan naman ay due process, hindi ba't ang mismong impeachment trial na nga ang mismong venue para doon? Maririnig ang dalawang panig. May ebidensya, may magdedepensa. That is due process. So
Tama.
what are we afraid of?
Oo.
At dahil nandito rin po sa gallery ngayon, Mr. President, ang isa sa mga constitutional commissioners na si Christian Monsod, di lalo po akong confident na mag-take exception sa isang sinabi kanina ng good gentleman mula sa Taguig at Pateros na dapat mahirap ang proseso ng impeachment. Kontra po doon ang pananaw ng Constitutional Commission kung mababasa po natin ang records ng deliberations ng komisyon, partikular sa panig ni Commissioner Regalado. Muli, patuloy nating nirerespeto ang Korte Suprema. Pero pwede mong respetuhin ang isang institusyon habang nagtatanong at pinag-uusapan ang kanyang desisyon. In Firestone Ceramics Inc. versus Court of Appeals, the court conceded that it is not infallible. Should any error of judgment be perceived, sabi nila, it does not blindly adhere to such error. In this jurisdiction, rectification of an error more than anything else is of paramount importance. In the 2010 letter that I mentioned earlier, the UP law professors said that the position of the Supreme Court as the final arbiter of all controversies requires competence and integrity completely above any and all reproach. A breach of these values, the professor said, does violence to the primordial function of the Supreme Court as the ultimate dispenser of justice. And the UP Law Dean who led that letter to the Supreme Court, walang iba po kundi ang nagsulat ng desisyon na ating pinag-uusapan. Dear Mr. President, dear colleagues, I believe this decision is of the highest public interest, whose consequences will echo through time and history.
May kasalanan talaga kasi si Sara kaya ayaw nila.
At hihimayin ito ng lahat. Mula sa mga estudyante, mga journalist, mga political analyst, mga academics, at higit sa lahat ng ating mga kababayan. One day, and this day will come, history will judge all of us based on our actions today, August 6, 2025. When history comes to remember, let's hope we stood where it mattered, that even in the face of doubt, we did what was right and just. With deep respect for the Supreme Court and all institutions of our country, Mr. President, I therefore second the motion to table the motion to dismiss the impeachment complaint until the decision of the Supreme Court has attained finality. Salamat po, Mr. President.
Oh, ha? Meron na
Mr.
silang
President,
ano.
quick
Noted and entered into the records.
Meron silang
Senator Marcoleta.
merong
unang-una,
iniisip yung
sinabi ko pong
mga
speculative. Sapagkat it was not based on my own speculation. It was based on
Tama na, Marcoleta.
my
Punyeta.
long practice as a litigation lawyer. Wala pa po akong nakitang isang unanimous decision. Ewan ko lamang po kung merong magbo-volunteer ngayon na abogado, in the last 40 years na sinasabi ang isang unanimous decision na ang karakter niya ay sinabi na ab initio, void ab initio, unconstitutional, violative of due process. Maybe if we can speculate that all the members of the Supreme Court after the filing of the motion for reconsideration will resort to their worst, will resort to the worst angels of their
Wala
nature.
na,
Baka
Marcoleta,
ganun lang.
budol din yan. Sinungaling, ganun.
What do we expect? We expect that 8 of them will reverse themselves altogether? Kung sakasakali naman po na in-archive natin or whatever word is applicable at sinabi under miraculous circumstances sinabi ng Supreme Court, we are all reversing ourselves. Di continue natin. Anong problema? Pero kagaya po na sinasabi ko kanina, Mr. President, ang pagkakaluto nga po ay hilaw eh. Ipinipilit po ngayong ipakain sa Senado ang
Hilaw
isang
daw.
bagay na hilaw.
Ilaw daw ang pagnanakaw ni
Paano? Sinabi po ba ng Supreme Court na wag na kayong mag-impeach? Hindi po. Binigyan po tayo ng guidelines. Alam po ba ninyo kung bakit binigyan na ng guidelines ng Supreme Court kung paano mag-impeach? Kasi po, Mr.
Oo,
President, if
masakit.
you recall, the Supreme
Masakit
Court
talaga
issued
ang
a notice
magnakaw.
on July 8,
Masakit
2025,
manakawan.
requiring at least 11 information from the House of Representatives and the Senate. The Senate made a manifestation na wala po kaming maibibigay sapagkat lahat po niyan ay makukuha ninyo sa House of Representatives. Alam po ba ninyo na apat sa
Tama
hinihingi
dyan,
ng
Yosh.
Supreme Court ay nandun po sa puso ng due process? Ano po yung hinihingi? Sinabi lamang po ng Supreme Court, pwede bang ibigay nyo sa amin kung lahat ng miyembro ng House of Representatives ay binigyan ninyo ng kopya at kailan? Pwede bang ibigay nyo sa amin ang timing kung kailan nyo ibinigay at binigyan, kung paano nyo sila binigyan ng pagkakataong mabasa yung impeachment complaint? Pwede nyo bang ibigay sa amin kung every article of impeachment ay nakalagay doon ang mga dokumento na nagpapatibay
Oo,
ng
nandoon
artikulo?
nga eh.
Pwede nyo bang
Sinungaling
ibigay
yan.
sa amin
Matanda.
kung nagkaroon sila ng pagkakataon talaga na mabasa yung impeachment complaint? Alam po ba ninyo kung anong sagot ng Solicitor General in behalf of the House of Representatives? Ito po yung sagot nila.
Sinungaling naman yan
It
si
is the
Marcoleta
position
eh.
of the House that these matters pertain to its internal proceedings, which have always been regarded as beyond the
Hoy,
jurisdiction
Antonio, yung build, no? Nagigiba yung mga tulay, no? Build ba yon? Ha? Kinurakot, no? Yung Manila Bay, naganda bara-bara. Ay nako, pinagpapatuloy mo, sipain kita dyan, Antonio, eh.
and scrutiny of this honorable court. Sa Tagalog po, wala po kayong pakialam dito sa amin. Yung inihingi po ninyo, kami lang po yun. Para tinatanong lang naman po eh. Binigyan nyo ba ng pagkakataon sila na mabasa? Bakit? Mahirap po ba sagutin yun? Ano pa po sinabi? This is especially because the matters referred to the preparation, circulation, and perusal of the impeachment complaint as well as its attachment are not governed by specific constitutional provision or the House rules. So dahil po wala sa Constitution at wala rin po sa House rules, ano po yun? Wardi-wardi na lang. So ibig sabihin talaga, kaya po pala ang dami kong kasama doon, wala talaga silang kopya. Ako nga po hindi nabigyan eh.
Oh, ba't ka bibigyan?
Bakit hindi po kinakailangan bigyan lahat? Baka sakali,
bakit? Inumpisahan
malay
nyo
po
ba
niya,
yung
baka pumirma
impeachment?
ako, hindi ba?
Kung inumpisahan nyo yung impeachment, magkakaroon kayo ng kopya. Hindi nga raw pwedeng ibigay agad eh, para raw sa kasiguruhan ng mga witness eh. Naiintindihan nyo ba yon?
Ito yung tinatanong po ng Korte Suprema. Kaya lang po siya nakapagbigay ng additional guideline sapagkat isip-isipin mo, sasabihin sa Korte, wala nang pong masamang tinapay ang Korte. Pwede po malaman namin kung talaga nagkaroon ng pagkakatong mabasa man niya lang, ma-appreciate ang bawat dokumento na nakasalig dyan sa impeachment na yan. Para sa ganun,
wow.
ay boboto siya sang-ayon sa kanyang sariling kagustuhan.
Hindi na.
Matibay ang gusto ng ng Korte Suprema. Gusto niyang makita na lahat ay dumaan sa kaayusan.
Ayun.
Hilaw nga po eh, Mr. President. Kanina ko pa po pinaiintindi. Hilaw.
Transparent.
Ba't hindi po kayo magluto ng mas masarap na kanin?
Transparent ang impeachment kay Sara. Kung ano ang mga batas na i-impeach sa kanya. Kunyari lang to si Marcoleta ang hindi niya alam eh. 7 yun eh, 7. Ha? Alam niya naman yun lahat eh. Kunyari lang siya hindi niya alam. Magaling to magsinungaling. Tama yung yung kuryente. Ngayon. Tapos hindi raw siya Duterte Black. Hindi raw siya kasama sa PDP laban. Adopted lang siya. Adopted na nga eh, di kasama siya. Inampo na nga siya ng PDP laban, di kasama siya. Itinatatwa kayo nito ni Marcoleta. Tapos ngayon, ayan, bumabaliktad na naman siya. Sabi ko na nga ba kaninang umaga eh, babaliktad dyan si Marcoleta.
Para sa ganun po, hindi tayo mahirapan. Maghintay na lang po kayo ng 6 months. Pwede naman eh. Ba't pinipilit po natin yung isang bagay na hilaw at pinipilit yung ipakain sa atin?
Sus!
Mr. President, sabi ko po kanina, Mr. President, I am ready to amend my motion.
Kasi paulit-ulit na yan, paulit-ulit na yan si Marcoleta na pagsisinungaling niya, na hindi niya raw kuno alam kung ano ang nakasaad sa impeachment ni Sara. Hindi niya raw alam.
Kung kinakailangan po, that will be consistent on the respect accorded to the Supreme Court. Kaya lamang po, kailangan nating umaksyon. Sapagkat kagaya po ng nalalaman natin, naghihintay ang taong bayan na kailangan magkaroon po ng closure ito sapagkat kapag ito will be hanging on the balance, baka hindi po mabutihin ng ating mamamayan. Yun lang naman po ang pinakapunto rito, Mr. President.
Wala ka na Marcoleta. Wala ka na
What is
talaga.
the pleasure of the minority floor leader?
Hindi na kami maniniwala
Thank you, Mr.
talaga sa iyo,
President.
Marcoleta. Ayan makinig kayo ha.
Caution is the word simply being put forth by this representation, Mr. President. Because again, sabi nga, wala pa raw siyang nakita. The distinguished gentleman from Tarlac, with due respect, said wala pa siya nakita na unanimous decision ng Supreme Court na baliktad. No? Again, I said,
Meron.
there's always a first time. Bakit ko sinasabi ito? I will quote the Supreme Court themselves. In the Pedro versus Romasan Development Corporation, GR 194751, July 1, 2015, I quote, Supreme Court nagsabi nito while the Supreme Court's decisions are immediately executory, they are not considered final until the lapse of the prescribed period without a motion for reconsideration or upon denial of such motion. Sila nga mismo nagsasabi na hindi final eh. Ano ba naman ang masama na maghintay tayo na kung final na? For all you know, I might vote to
Nagkamali nga raw ang Supreme Court
the motion to dismiss. Hindi ba? If there is such a motion, because according to Senator Lacson, it does not exist in the Senate. It exists in the impeachment court. And what I am being told is that it should be the defense, the lawyers of the defense who should pose that motion to dismiss, not a judge.
Tama.
I agree with Senator Lacson. There is no such thing as a motion to dismiss in the Senate. In the impeachment court, yes. Thank you, Mr. President.
Hindi po ba inamid na natin, Mr.
By the way, just one last point.
Inamend na raw.
Why did the Supreme Court ask Sara to comment? Kung final and executory na yan, bakit si Vice President Sara was asked to comment by the Supreme Court just a few days ago?
Diba?
Diba?
Hindi naman
So, ibig
nagko-comment.
sabihin, talagang pakikinggan pa nila. At baka sakali makita nila, dahil yung mga abogadong nakapaligid sa kanila, nagbigay sa kanila ng mga maling figures at maling impormasyon.
Kasi pwede kasi.
By way of President, kaya nga po nag-speculate tayo rito eh. Hindi natin alam
Speculate
kung
mo,
ano
puro
iniisip
ka
ng Supreme Court.
speculate.
Pero sa ngayon, sinabi po niya, immediately executory at tayo lamang po talaga ang pinagsasabihan niya. At tungkol naman po sa motion to dismiss na minodify ko na kung ayaw po ninyo, wala po akong magagawa. Pero may I invoke Section 135 of the Senate Rules. Ang sabi po rito, if there is no rule applicable to a specific case the precedents of the Legislative Department of the Philippines shall be resorted to. So ang dami po nito eh. Dito po magkakaroon ng motion to dismiss dito. Lahat po ng precedents, kahit na wala po tayong specific rules, ay observe po natin ang section 135 ng ating rules. Pero dahil inamend ko na nga po, kung pwede na po yung motion to archive, which is consistent to the immediate execution of the decision of the Supreme Court addressed to this august chamber. Okay, bakit naman po pinipilit pa nating i-delay based on speculation? Based on the fortunes of whatever the Supreme Court will decide later on, which is based on impossibility.
Noted and entered into the records.
Mr. President. Just
What is
for,
the pleasure of the Honorable Cayetano?
just 1 minute, Mr. President. Just for the information of the body, there's actually a Supreme Court case about the power to dismiss a case. Ito po yung Velasquez Jr. versus Lisondra Land.
Hoy, alam na alam namin kung ano ang kaso ni Sara. Alam na alam namin ang pagnanakaw niya. Ha? Sino to? Gnob.
2020 case. Ang sabi niya, in order for the court or an adjudicative body to have authority to dispose of the case on the merits, it must acquire jurisdiction over the subject matter. It is axiomatic that the jurisdiction over subject matter is conferred by law and not by the consent or acquiescence of any or all of the parties or by erroneous belief of the court that it exists. Thus, when a court or tribunal has no jurisdiction over the subject matter, the only power it has is to dismiss the action. So Supreme Court na mismo nagsasabi na pag walang jurisdiction, it does not exist. So sabi ng Supreme Court dito, void ab initio eh. Yung articles of impeachment. Pag tinitingnan natin rules natin, the impeachment court is triggered by an articles of impeachment. Kung walang article of impeachment, walang court. So yes, it's true na it is a fact, not an operative fact. It is a fact na nag-robe tayo, nandito tayo. It is not an operative fact na meron tayong jurisdiction doon. Lastly, Mr. President, sa Rule 39, Section 4, judgment not stayed by appeal. Judgments in actions for injunction, receivership, accounting, support, and such other judgments that are now or hereafter be declared to be immediately executory shall be enforceable after their rendition and shall not be stayed by an appeal. Some may say this is for injunction, receivership, etc., and not for the impeachment court. Ang point ko lang, Mr. President,
Your Honor,
meron naman tayong...
This is a case for injunction.
Yes.
Filed by the Vice President against both the Senate and the House.
Thank you for that clarification. But even if it was not, Mr. President,
alam niya eh.
that is why if we, that the gentleman from Tarlac already said he's amendable. So kung halimbawa something like we move to act upon the Supreme Court decision and archive the case. Kasi yung Supreme Court decision, when you act upon, ano ba sabi niya? Immediately executory, ano ba sabi niya? Void ab initio. Ngayon, kung halimbawa, na-reconsider at biglang sinabing tuloy, wala rin naman na epekto yun sa motion na we act upon the Supreme Court. Then, at the proper time, someone can say here, we will act upon the latest decision of the Supreme Court. Diba? So, I'm just saying this in the spirit,
Tama
Mr.
ka dyan,
President,
Josh.
na pag nakaboto tayo,
Tanga-tanga eh.
at least klaro kung anong pinagbobotohan. Because some of us might not vote for the motion to dismiss.
Nabubuking siya sa
pangungurakot
pangungurakot sa pagnanakaw niya eh.
Dismiss. But I
Ang
don't think
daming
that's our point.
nabubuking
Our
sa
point is
kanya eh.
lagyan ng katahimikan to for a few months.
Tapos itong mga
February 6,
senador,
game na ulit.
Noted and
pinagtatanggol.
entered into the records. Majority Floor Leader.
Thank you, Mr. President. Next to interpolate, Mr. President, is the distinguished gentleman from
Tama,
Pampanga.
MR.
But the gentleman from Pampanga is yielding the floor to our Deputy Minority Leader.
Yes, what is the pleasure of the Honorable Ontiveros?
Thank you, Mr. President, and to the good gentleman from Pampanga. Gusto ko lang pong bigyan ng point of information, sagot dun sa tanong ng good gentleman mula sa Tarlac, that in fact, the Supreme Court has reversed a unanimous decision in a lot of instances before. Dalawa lang po ang ibibigay kong halimbawa. League of Cities of the Philippines versus COMELEC. Original decision 2008, reversal on motion for reconsideration
Diba?
2009.
May
Isa pa pong
nare-reverse naman
halimbawa, International Service for the Acquisition of Agri-Biotech Applications Inc. o ISAA et al. Versus Greenpeace Southeast
Hindi
Asia.
bagay ang Sara for
Original
President.
decision,
Parang
unanimous,
baliw.
December
Baliw
8,
yung Sara.
2015.
Baliw for President.
Reversed unanimously on
Ayaw namin ng
MR
baliw na
July
President.
26, 2016. So, hindi lang po tulad nung sinabi ni Minority Leader na there's always a first time, it has happened before. So, yung ganitong klaseng milagro na hinahanap, posibleng mangyari din po
tama
dito
yan, Josh.
sa kasong
Agad,
pinag-uusapan
walang
natin. Malay po
magtatagal.
natin. Salamat po, Mr.
Noted.
President. Salamat
Mr.
sa good
President,
gentleman
may I know
from Tarlac.
from the
Entered
good
into the
senator,
record. Senator Marcoleta.
may I know from the good senator if these decisions are bank decisions?
Wow.
divisions.
Gagaling-galingan talaga to si Marcoleta eh.
Yes, Mr.
Halata namang
President, and
sinungaling
bank
siya eh.
decisions po.
Wala
Well, you
nang
have to,
kredibilidad
cite
si Marcoleta.
the
Wala na.
the
Gladly
jurisprudence.
cite the GR
Sinungaling.
number po bang hinihingi, Mr. President?
Pagka sinabi pong bank, lahat po ng members ng Supreme Court, 15 of them, unanimous.
To
Kasi
reiterate
po,
what
baka division lang yan, 5 lang yun. Hindi po
No,
bank
Mr.
yun.
President, to reiterate what I already said, mga ano po ito,
Tingnan mo,
mga
tatanga-tanga.
reversal ng unanimous.
Tanga-tanga na reverse na nga. Tapos sasabihin baka 5 lang. Paano yan mare-reverse kung 5 lang? Naku, Marcoleta. Inaamag na yung ulo mo. Ay nako.
Supreme Court decisions.
Yes, but I am
At sa
asking for
dalawang
qualification,
halimbawang
Mr. President,
binigay ko
whether
po
these are bank
on
decisions
MR.
Tingnan mo,
or
tingnan mo.
decisions by a division. And whether or not they
Mr.
were
President,
characterized
sinabi
by,
ko rin na po kanina ang
Sandali
bank
po.
decisions po ito. Ay, hindi po.
whether or
I
not
am
the
replying to the
decisions
question.
are characterized by the following qualifications. One, unconstitutional.
Magaling si Marcoleta magsinungaling. Hoy.
Constitutional, void ab initio, violative of due process. All these are present in those jurisprudence and cases as you cited.
Mr. President, bagamat para itong yung pinag-uusapan natin kaninang operative facts, kanina simple lang yung tanong eh. May kaso na po ba na ang Supreme Court sa unanimous decision ay ni-reverse ang sarili nila? Ngayon may dinadagdag na tarong. Pero sige po, yung League of Cities of the Philippines versus COMELEC, the Supreme Court in its original decision in 2008 unanimously declared the cityhood laws unconstitutional. I will have to get more information po on the ISAA reversal of unanimous decision. Pero malinaw na mga sagot na po ito dun sa original na tanong. So the original assertion na hindi po natin alam kung na-reverse na ng
The gentleman from Pampanga, Senator Kiko Pangilinan. Yes, Mr. President.
Senator Pangilinan is recognized and may proceed. Should the gentleman,
Hinihintay ko si Robin eh.
Yes, Mr. President.
Yes, Mr. President, this is not an interpellation, but with the permission of the gentleman from Tarlac, we will just make a manifestation.
The gentleman may proceed.
Thank you, Mr.
Anong issue
President.
ng PhilHealth?
Mr. President, marahil marami ang
Di
nagtataka
kasi kayo
o
nakikinig, yung
ano nga
PhilHealth.
ba ang pinakapunot dulo o
Ha?
debate na
Yung PhilHealth,
pinag-usapan
kinurakot
dito
ni
sa
Digong.
Senado? Tatlong sa probisyon ng saligang batas. Tatlong kapangyarihan ng tatlong sangay o tatlong governmental entities. Yung kapangyarihan ng judicial review ng Korte Suprema, yung sole power ng House of Representatives to
Nako,
initiate
Kiko,
impeachment
tinggilan mo na yan.
proceedings, at yung sole power ng Senate bilang impeachment court
Tama,
para
Roberto.
litisin
Ito si Marcoleta
at,
nagtatanga-tangahan eh.
ang isang impeachment case. Narito tayo ngayon, nagdedebate dahil yung judicial review power ng Supreme Court ay pinawalang bisa. Ang sole power ng House of Representatives para ito ay mag-initiate ng impeachment proceeding at pinawalang bisa rin ang kapangyarihan ng Senado bilang sole
O di tanggalin na kayo.
having the sole power to try
Tatanggalin na
and decide
talaga kayo.
impeachment cases.
Supreme Court
Dahil
na
dito,
lang.
saan tayo tutuloy?
Wala na.
Merong na ring mga ruling ang Korte Suprema kung paano natin iha-harmonize o ihahambing ang mga nagtatalong probisyon ng saligang.
Di mo ba alam, ano?
Sinabi ng Korte
Jansky,
Suprema
ako
sa
kami ang
kaso
nagpapasweldo
ng,
kay
Civil
Marcoleta.
Liberties
Ha?
Union versus the Executive Secretary.
Taong bayan ang nagpapasweldo sa
pati na
kanila.
rin sa Francisco case versus
Alam mo ba?
HOR.
Anong wala sa
The
kalingkingan?
Constitution is to be interpreted as a whole, and one section is not to be allowed to defeat another. In this case, judicial review should not be defeated. The sole power of the House to initiate should not be defeated. And the sole power of the Senate to try and decide cases, all mandates, all duties, all constitutional
ambag.
powers that do not belong to us, that was given to us, not by any whim, but by the Constitution, all of whom here sworn to uphold and defend.
BDS 32
Kaya,
million bo.
ano ang
Mukha
way
nyo.
forward?
100 nga
Sabi
lang
nga,
kayo pagka
May
nagrarally.
mga minungkahi, si Justice Ascuna, hayaan sa MR, payagan sa motion for reconsideration, payagan na magkaroon ng operative facts doctrine para yung anuman ang pinagpasya ng Korte Suprema sa kasong ito should apply prospectively, number one. Pangalawa ay sa pamamagitan ng MR pa rin ay mabigyan ang House of Representatives na maituloy ang kanyang kapangyarihan to initiate, and at the same time mabigyan ang kapangyarihan ng Senado to try and decide the case. Kaya habang naririyan ang MR, baka sakali at nangyari na nga na the Supreme Court has reversed itself even in a unanimous decision. But even assuming it does not reverse itself in this case, the Supreme Court may modify its ruling. And therefore,
Pwede
if
rin
it modifies the ruling, assuming
Isa pa
that it
tatandaan nyo, nagsalita na si Romualdez na ipapa-impeach niya rin ang Supreme Court. Tandaan nyo yan.
modifies but does not reverse itself, should we not await the resolution of
Ako
the
feeling
motion for
DDS lang.
reconsideration before we vote? Today, we hold it in abeyance or we table it. Mr. President, if I may add, the SC, the Supreme Court, hindi niya binanggit. Binanggit niya nawalan ng
Ano ba yan?
jurisdiction ang
Hindi niya
Senate
binanggit,
Impeachment Court. Pero ang ibig sabihin nun ay pinawalang bisa, ginawang void ab initio ang mga kilos at pasya ng Impeachment Court. The convening of the Impeachment Court
Bakit niya
was
ninal
voided.
and void?
The majority decision to remand the complaint to the HOR was voided. The summons by the impeachment court were all voided, which brings us to the question: who now is deciding the impeachment case? Now that all the decisions of the impeachment court have been voided. It's a tricky question, Mr. President. But if I were to be an impeachment court judge, I would argue that we have to, in the MR, in the motion for reconsideration, intervene and uphold the impeachment court's exclusive power to try and decide the case. Why? Because it is the constitutional
Si
duty
Garcia, ano yung sinabi
to
ko?
do so. It is the order of the Constitution. We are not defying the judicial review powers. We are upholding the sole power of the Senate to try and decide impeachment cases. But having said that, sabi nga, it is our view, and this is shared precisely by former Supreme Court Chief Justice Panganiban, former Chief Justice Puno, former Constitutional Commissioner and Justice Ascuna. They have seen or they have read their decision and they too have said that the Supreme Court erred on a matter of facts. And if the Supreme Court erred on a matter of facts, how can you be right with the law if you are wrong with the facts? And if you are not right with the law, why will the impeachment court and the Senate for that matter decide on the matter today? Why not wait for the motion for
Matching.
reconsideration?
Dito kay
Siguro
Matching.
naman, hindi natin binabangga ang Supreme Court. Hindi natin binabangga rin ang House of Representatives.
Wala
Dahil
na, binangga
meron
na.
ding prinsipyo ng
binangga na.
parliamentary courtesy. Meron ding prinsipyo na kinakailangan natin bigyan ng respeto ang co-equal. We are a co-equal to the House of Representatives.
Co-equal nyo kasi ang Supreme
ano na lang
Court
ang magiging repercussion
Ano?
na ito ang House of Representatives nag-file ng motion for reconsideration, hinihiling nila sa Supreme Court na baguhin ang ilang mga findings of facts, baguhin ang kanilang naging desisyon. Habang pinangunahan ng Senado, sabi, wala kaming pakialam sa inyong motion for reconsideration, i-dismiss namin ang kasong ito. I think out of courtesy for a co-equal, we should respect the House of Representatives. In the same way, if the Senate
Co-equal nila
would,
nga ang
at a
SC.
future time, file a case before the Supreme Court and seeks a motion for reconsideration in a matter that involves the House,
Wala na talaga.
we would like to
Tanggalin
think
na
that
yan.
the House
Tingnan natin.
will not
Tingnan
act
natin yung nagaganap sa labas ng
to
Senado.
have the case dismissed pending the MR out of respect for a co-equal. Sana pag-aralan natin ang husto ang pagpasya ngayong hapon. Sabi ko nga, the findings of grave abuse by the Supreme Court, thereby removing or taking away from us the jurisdiction, na wala tayong jurisdiction, that jurisdiction was not acquired on the basis of facts that are flawed, where then is the grave abuse? I don't know what the ruling will be. Perhaps they will say, yes, there was no grave abuse of discretion on the part of the House because of the one-year bar, which was not actually the fourth complaint was not bar. I don't know. But whatever it is, hintayin na lang naman sana natin. Respetuhin naman natin ang ating co-equal. Why the convening of the impeachment court is the way to go? Dahil pag tayo ay bumoto ngayong hapon, ngayong gabi, na i-dismiss ito, aksyonan ang impeachment complaint, we will be acting beyond, without legal authority dahil wala naman sa atin yung impeachment complaint. Wala namang kapangyarihan ang Senado in plenary, ultra vires,
Ibinalik nyo.
without legal authority ang magiging desisyon natin. One final point. In the Corona impeachment trial,
Pasong-pasong kayo eh.
nang himasok, nag-TRO ang Supreme Court para sa mga bank accounts. Ano ang ginawa ng Senate Impeachment Court? Bumoto 13-10 para respetuhin ang Korte Suprema. I did not vote in favor of the TRO or respecting the TRO. But the Senate, as an impeachment court, voted and we respected it. Because it was the Senate impeachment court that decided. It was not the Senate. It was the Senate impeachment court that seeing perhaps that we needed to harmonize the power of judicial review, the power of the Senate as an impeachment court, to have the sole power rather to try and decide cases, seeing that the Senate in impeachment court decided to harmonize the conflicting provisions of the Constitution. I think we should, as a Senate impeachment court, do the same. Kung ipagbobotohan na respetuhin ng Korte Suprema para walang constitutional crisis, so be it. But it ought to be the Senate impeachment
Tingnan
court
mo nga yan kung
that
adik ang itsura niyan. Ha?
asserts its sole power to try and decide
O, ayan ang picture ko. O, ano?
cases.
Mukha
Yun
bang
na lamang
adik
po,
yan?
and I associate myself
Baka maganda
with
pa
the
ako sa
motion
asawa mo.
of the minority leader that we lay
Sino
on
to
the
nagsabi
table
na to?
the matter of the impeachment case and action.
Just a point of information, for the record and for the information of the body. Chair confirms the manifestation earlier of Senator Cayetano with respect to Section 4, Rule 39 of the Rules of Court that says that decisions of the court are not immediately executory
Si Kim.
unless the decision says so. In this case, the decision specifically stated that it is immediately executory. Number two, again, just for the record, the Supreme Court itself, through its spokesperson, after the House filed their motion for reconsideration, reiterated the immediately executory nature of the decision of the Supreme Court.
Salita
And
na si
finally,
Kilay, oh.
the Supreme Court's own internal rules states that the entry of judgment shall be the date such decision or resolution becomes executory unless the court directs its immediate execution. I'm quoting and citing AM number 10-4-2-20 rather SC, specifically section 16, rule 16 rather, section 1. So there are conflicting authorities with respect to the opinions raised by the various members. Senator MATCOLETA, what is your pleasure?
Just a quick reaction, Mr. President,
Bibida
on the
na naman si
manifestation of
Marcoleta.
Senator Pangilinan.
Baliw.
In the exercise of the Supreme Court's judicial review, wala po siyang dinidefeat doon. Hindi niya po kinukuha yung sole power of the Senate to try and hear impeachment cases. Hindi rin po niya kinukuha yung exclusive authority ng House to initiate impeachment. Dito po sa desisyon na ito, kung kinakailangan ulitin po o ulit-ulitin pa, ang sinabi lamang po ng Supreme Court, yung process, yung procedure hindi natupad. Ang dami po niyang hiningi, kagaya po ng binanggit ko na, ayaw pong ibigay. Yun naman pong mga tuntunin ay hindi naman po sinunod. Katulad nga po nung immediate referral, yung pag-refer sa Committee on Justice, yun pong pag-include sa order of business
Ulit-ulit.
at pag-archive. Mali din po sapagkat hindi naman po 10th session day yun 11th session day. Katakot-takot na paglabag po ang aking pong inihayag sa hapong ito.
Talaga ba?
Wala naman pong gustong magpatibay at o kaya sansalain o kaya sabihin na mali ang aking sinasabi.
Oh, paano nga?
Andito po yung kopya ng order of business na pinagbasihan ng Solicitor General na kung saan sinasabi po niya na yung 4 na impeachment complaints in-include daw po sa order of business. Tingnan po ninyo, wala kahit isa. Ang ginamit po nila ay journal, hindi po yung order of business na kung saan ginamit lamang po na additional reference of business. Ngayon po, yung cooperative pact na sinasabi natin, hindi rin po pwedeng mangyari yun sapagkat ang pinakabasihan po nun ay equity and fairness. Paano po yung fairness dito? Sari-sari nga pong violation, kaya nga ang paghahanilin tulad ko na nga, parang nagsaing ng kanin, talagang hilaw po . Bakit ipipilit natin? Ang alternative lang po, Mr. President, gawin po natin na tama. Iluto po natin ng tama para hindi tayo magkahirap-hirap dito. Isip-isipin po ninyo, sinasabi ng ating Constitution, isa lamang pong impeachment proceedings ang pwedeng i-initiate sa isang opisyal ng gobyerno at hindi po pwede ang 2 beses sa loob ng 1 taon. 4 na beses po ang ginawa nila.
At kunwari, in-archive po yung tatlo para lamang palitawin na isa lang ang nabuhay. Nasaan naman po yung katwiran? Kung sarili pong tuntunin na ayaw pong sagutin, ayaw pong
Ang pagkakaalam ko, isang beses lang
pagkatapos
nag-impeach
ipipilit
ang
po natin,
ano.
sapagkat nag-MR sila. Ano po ang kasaysayan ng MR? Sabi ko nga po, napakasimple po nung
Isang beses lang
one-year
nag-impeach ang
ban rule
Congress.
ng Supreme Court. And the Supreme Court is not even obligated and expected to conduct a microscopic, a forensic and scientific scrutiny of this provision, for the pertinent language and the relevant meaning is as clear as daylight, Mr. President.
Galing.
Ano po yung gagawin na? Hihintayin po ba natin kung ano ang magiging kalalabasan po ng MR na sa aking pong palagay, hindi po speculation, sabi ko nga po.
Pio,
Unanimous
kanina pa
decision
kanina pa niya yan
and bank
sinasabi,
decision
paulit-ulit na lang yan si
ab
Marcoleta.
initio unconstitutional, violative of due process,
Inuulit-ulit
immediately
nga,
executory.
matanda na kasi,
Sino
senior
po
na
kaya
kasi,
kahit
kaya
isa man lang na
ulit-ulit.
miyembro ng Korte Suprema ang magtatangka na i-reverse niya yung sarili niya? Ito po yung
Nagmamagaling.
speculation dito.
Speculation na
Ngayon,
naman.
nakikinig po ang taong bayan.
Kanina pa yan, speculation niya raw yan eh.
Nakadepende po ba ang aksyon natin? Doon po ba nakahang ang gagawin natin sa isang motion for reconsideration
Ay, bobo
na
siya.
sa aking
Hindi,
palagay,
bobo siya.
matibay po ang aking palagay sapagkat this is borne out by my experience
Tapos
of
na
more
yung
than 20 years
kredibilidad
of
ni
legal
Marco
practice,
Beta.
Mr. President.
Tandaan mo yan, di na yan
Yung ibig lang
mananalo.
sabihin nung immediately executory, sige, pwede kang mag-file ng MR. But you are wishing for the moon. Sumusuntok ka sa hangin.
Talaga ba?
Yun po ba ang basihan natin? Kaya hindi tayo makapag-desisyon, Mr. President? Sana mayroong mas matibay sanang desisyon. Meron sanang mas matibay na katuwiran. Hindi yung pong nakasalig po sa hangin. Nakasalig po kung puputok ang bulkan o hindi.
Nanalo yan?
Hindi po yata ganun.
Hindi yan nanalo. Tingnan mo.
Ang gawain ng Senado, Mr. President.
May kaso pa yung
Tinangka ko na
COMELEC.
nga pong i-amend.
May kaso pa yung
Kung ayaw po
COMELEC.
ninyo yung motion to dismiss any other language that will put to rest this issue in obedience and in complete respect to the last word of the Supreme Court, it being immediately executory, Mr. President.
Wag ka na,
What is
Marco
the pleasure of
Beta.
Senator Aquino? I saw him raising his hand earlier.
May kaso
Senator
ang
Aquino
COMELEC.
seems to be
May
yielding
kaso.
to Senator.
Mr. President,
Dahil
may
sa
we recognize
pandaraya.
Senator Lacson, Mr. President.
Thank you, Mr.
With the
President.
permission of Senator Aquino, Senator Lacson is recognized.
Thank you, Mr. President. Gusto ko lamang pong itama ang misimpression that may have been created by the interpretation of the Honorable Marcoleta do sa
Ayan na naman.
Section
Sasagutin na
135.
naman ni Ping. Kasi
Sabi niya,
paulit-ulit eh.
Yung supplementary application of the rules of court. Basahin ko po yung Section 135, Mr. President. If there is no rule applicable to a specific case, the presidents of the Legislative Department of the Philippines shall be resorted to. And as supplement to this, the rules contained in Jefferson's Manual, Riddick's Precedents and Practices and Hin's Precedents. Wala naman po ako nakita doon sa enumeration na rules of court. Di ba po sabi ng mga abogado, di ba yung expressio unius est exclusio alterius. What is expressly included excludes all others. So wala naman pong rules of court. Kaya gusto ko pong itama yung medyo hilaw pong interpretation
Di
ng
ba?
ating Honorable Marcoleta.
Oh, hilaw.
Maraming salamat po, Mr. President.
Noted.
Mr. President, may we recognize Senator Bam Aquino has been waiting for his turn to interpolate the gentleman from Tarlac.
Senator
So moved,
Aquino is
President.
recognized and may proceed.
Maraming salamat.
Gentlemen, allow it.
Ako, isa pa to. Si Aquino.
Maraming salamat, Mr. President. This is a manifestation, not an interpolation, Mr. President. At kanina pa ako nakikinig.
The gentleman may proceed.
Marami po sa mga puntong nabanggit na ng mga kapwa nating senador ay sumasang-ayon po tayo at tama, no? Napag-usapan na po ang independence ng Senado, kung
Tama.
gaano kahalaga ang papel na ginagampanan natin sa ating bansa, sa checks and balances ng ating gobyerno. At alam rin naman po ng mga kasama natin na sa caucus, sinabi ko rin po na ang posisyon ko ay dapat mag-convene ang impeachment court
at doon magdesisyon kung ano ang mga susunod na hakbang
Kunyari
pagdating
ka
po
pa
sa
naman,
impeachment
Aquino.
case. That's known to everyone. I've said that in the media. Mr. President, in our history, nagkaroon po ng mga panahon na ang Senado ay nag-assert ng kanyang independence bilang isang co-equal branch of government. Nangyari po yan many times. I remember in the 90s, kahit po ang executive, at that time, President Cory Aquino nagnais na manatili ang US bases dito sa ating bansa. Yung Senado, nanindigan. Kahit puro kaalyado, kahit puro kakampi at kamag-anak nasa Senado, nag-decide pa rin yung Senate to assert its independence and to do away with the US bases. Nangyari po yan many times in our history, Mr. President. Kaya palagay ko, yung role ng Senado napakahalaga pagdating sa pagpapanatili ng checks and balances. And Mr. President, marami tayong tungkulin. May tungkulin gumawa ng batas, may tungkulin sa pagbuo ng maayos na budget, may tungkulin ng oversight, pero meron din pong tungkulin pagdating sa pananagutan or accountability. At yun po yung sole power to try and decide all cases of impeachment. Ang posisyon ko, Mr. President, at nabanggit rin ito ng iba nating mga kasama, ay mahalagang i-assert natin ang ating independence. Mahalaga po na itong papel na ginagampanan natin sa ating Constitution ay pahalagahan po natin. Mahalaga po na manatili ang independence ng ating Senado bilang isang co-equal branch of government. Mr. President, posisyon ko rin po na nagsimula na ang impeachment proceedings. Nag-robe na po, nagsimula na, merong summons na binigay, may response na po si Vice President Sara. Kami pong mga bago, may mga robe na rin po pero hindi pa po nadudumihan. Hindi po magagamit, no? Ang posisyon ko po, mag-convene ang impeachment court at doon natin i-decide ang mga bagay-bagay na ito. Mr. President, may dalawang bagay rin na nailabas, no? Na hindi pa siguro na pag-uusapan. Let me read, Mr. President, Article 9, Section 3 of our Constitution, Accountability of Public Officers. In case the verified complaint or resolution of impeachment is filed by at least one-third of all members of the House, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed.
Diba?
Wala pong dagdag po dito. No? Dito po sa gallery, kasama ho natin dalawang framers of our Constitution. Nandito po si Professor Ed Garcia at si former Chairperson Christian Munsod. Kanina po, nagbubulungan kami. Sabi ko, nung ginawa nyo to, bakit parang ganun kasimple? Simpleng-simple lang, ito lang. At sabi nga po nila, noon daw, 1/2, 2/3, binabato 1/2 sa deliberation, nag-end up sa 1/3. At yung desisyon ay dahil sa kabilisan. Dahil mahalaga daw na mabilis, pag may 1/3, members of the House ang pipirma, mabilis na pupunta po sa Senado. At ito po, tinatanong ko sa kanila dahil sila po yung nagbuo ng ating Constitution. You know, many times, Mr. President, umiikot tayo sa ating bansa. I-bring up ko lang po yung free college law. No? Marami po sa atin dito nagtulungan para sa batas na yan. Meron kaming nakausap na eskwelahan. Ini-explain sa akin yung opt-out provision. Kung paano sila nag-charge ng mga estudyante dahil sa opt-out provision. At sabi ko sa kanila, mali. Mali ang interpretasyon ninyo. Yung interpretasyon ninyo, wala yan sa aming intensyon. Ang intensyon po namin, libre ang kolehiyo sa mga kabataan. At nung nag-argumento po sa akin, ang sabi ko, mas alam ko yan kasi ako ang nagbuo ng batas na yan. Mas alam namin yan dahil kami ang nagsulat ng provision na yan. In the same sense, Mr. President, the framers of our Constitution, mas alam po nila. Mas alam nila kung ano yung intent ng ating Constitution. Wala pong labis, walang dagdag. Many times, Mr. President, tinatanong tayo, usually pag campaign time to, tinatanong kami, Mr. Senator, hindi ba dapat merong educational attainment requirement yung pagiging senador? At sinasabi ko po lagi, wala, kasi wala po yan sa ating konstitusyon. Wala pong dinagdag, huwag tayong magdagdag nang wala pong nakasaad po dyan. So gaya po niya, no, binabanggit ko lang po dito dahil na pag-uusapan, may mga dinagdag na mga procedure. Alam ko po, siguro, tama po ang sinasabi ni Senator MATCOLETA, baka maganda naman ang intensyon ng Supreme Court. Pero aminin na po natin, wala po yung ibang mga bagay dyan dito po sa ating konstitusyon. Pangalawang punto, ito po, hindi rin po napag-uusapan pa. Nabanggit po dito, wag na tayong lumaban kasi matatalo rin naman tayo. No? Of course, Mr. President, it is improbable, aminin ko po yan, very improbable na magbago ang Korte Suprema with 15 votes. But it's not impossible. Improbable at
Gago.
impossible, magkaiba po yan. Firstly. But secondly, Mr. President,
It's
may
not
mga panahon
impossible ka pang
na
nalalaman.
kahit alam nating matatalo, kailangan pa rin lumaban. Tayong lahat po dito, dumaan po dyan. Ako po, dumaan rin po dyan. Kahit mukhang mahirap, kahit mukhang matatalo, kailangan lumaban pa rin. Tumayo tayo sa sarili nating paa, mag-assert tayo ng ating independence, ipahiwatig natin yung ating saloobin bilang isang grupo, ipakita ho natin na co-equal branch of government tayo, na meron tayong punto de vista.
Kailangan nating malaman ang nangyayari sa
kahit
mga pera
kaduluduluhan ng lahat,
natin.
respetuhan rin naman natin ang Supreme Court, mahalaga na mailagay pa rin kung ano ang nasa saloobin ng ating grupo. Mahalaga pa rin na malagay natin kung ano talaga ang posisyon ng Senado pagdating sa ating independent nature and being the sole authority to try and decide impeachment cases kahit po matatalo. So para sa akin po, hindi katanggap-tanggap ang posisyon na dahil matatalo rin tayo, huwag na tayong lumaban. Paminsan-minsan po mahalaga na ilagay naman natin ang ating posisyon kahit alam po natin na hindi pabor sa atin ang mga bagay-bagay. Thank you, Mr. President, and we'd like to thank Senator Marcoleta for his time.
Thank you, Senator Aquino. Noted and entered into the records. Senator Marcoleta.
Mr. President, I
Sasalita
thank
na naman
Senator
siya.
Bam for his manifestation. Totoo nga po na yung binasa niya sa
Basa na ang matanda.
Article 11,
Ayan na si Robby, no?
Section 3,
Tingin-tingin, no?
Paragraph 4, na sinasabi nga
Jesus,
naman,
Robby, nandiyan
in
ka
case
lang
the
pala.
verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall
Tatango-tango.
constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Ngunit, Mr. President,
May ngunit
this
siya.
cannot be applied in isolation of paragraph 8 na nandito rin po sa the same section 3, article 11. Ang sinasabi po sa paragraph 8, the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. Kaya po ang sinusunod ng House dapat yung rules of procedures in impeachment proceedings. Pero kagaya nga po na sinabi ko, imbes na sundin po nila, sila po yung gumawa nun eh. Hindi naman po nila sinunod. Kaya po ang nangyari, pinagsabihin ng Korte Suprema, ganito ang pag-file. Nagbigay nga po ng guidelines. Pangalawa po, yung kanyang sinabi na nakapag-umpisa na po kayo eh. Kanina po, kinwalify ko yun before I proceeded in my speech. Sabi ko po, the initial proceedings conducted by the Senate of the 19th Congress were not formally carried over into the Senate of the 20th Congress. Wala po talaga eh. I cannot recall, sabi ko nga,
I
and there is
cannot recall,
no
sinungaling ka kasi,
action
Marcoleta.
taken by this chamber, Mr. President, sapagkat ang alam ko,
Kahit
all
alam
these
mo,
proceedings were already deemed terminated at the expiration of the 19th Congress at noon of June 30,
Kaya nga
2025.
pumingiti-ngiti, hindi niya
And they
naiintindihan.
cannot be miraculously bring forth to life in this Congress where both of us now belong because this Congress is of different composition. Yun lamang po ang qualification doon, Mr.
Quick
President.
rejoinder, Mr. President.
Senator Aquino is recognized.
Yes, Mr. President. Babagitin ko lang po yung isang banggit ni
Marcoleta.
my co-gentleman from Tarlac, Senator Marcoleta. Mr.
Marcoleta.
President, may Section 4, may Section 8. Di ba? Ito po ba'y meant to reflect each other or not? Maganda pong matanong yung mga framers of the Constitution. Sila po yung nandun nung nabuo po ito. At malalaman natin yan kung meron pong oral arguments. Kung ibubukas po ang mga argumento sa publiko, pwede po magsalita yung framers of the Constitution, At doon po, sa posisyong yon, malalaman natin ano ba talaga ang intensyon ng mga gumawa ng ating Constitution. And Mr. President, pwede pong mangyari yon if we are able to table this matter and allow for these oral arguments to happen. Mr. President, hindi po ba maganda rin kung ang Senado mismo magsama-sama at magsabi sa Supreme Court, baka magandang magkaroon ng oral arguments dito po sa kasong ito. Yun lang po, Mr. President. Thank you.
Oh, tama, dapat lang, no? So, gusto niyo pang maging Vice President si Marcoleta, ayaw namin ng ng palit-palit ang utak, no? Aatakihin ang Duterte, ha? Ay hindi raw siya kalyado ng Duterte Black. Ha? Tapos ganyan. Sige na. Manood na kayo sa sa Senate at ako yung may gagawin lang, ha. See you sa next vlog ko. Salamat sa mga bisita ko, sa mga DDS diyan at sa mga loyalists pro Marcos diyan. Maraming salamat po at dito na lang po tayo muna. Mamaya balik ulit tayo. Salamat guys. Mga DD shit. Bye-bye.